Relic was placed. Four orders. Item 1 belong to Aizol bench.
May please, your lordships. My lords, am I audible?
Yes, yes.
My lords, I will be led by Senior Advocate Mr. PJ Saike in the instant case. However, my lord, I would like to mention that we have filed an IA in the instant case. We wanted to incorporate one order passed by Kala, Saitwal district. So, my lord, if liberty may be given that I may be allowed to file the IA today. The
For what?
Well, it's an additional document wanted to bring on record, but as per perhaps the procedure, it said it has to be filed by way of an IA. So therefore, IA has been filed only to bring on record a particular order.
Mr. PJ Sekar, tell me first one thing. Did you file any application under section 3G5?
That has been,
Have you filed?
That-
When?
it
After
was
the judgment?
after the judgment. That's it.
And when was the award issued? Award made?
My lord, the award was, the initial award was on 17/12/2020, 17/4/2021. And thereafter it was revised, my lord, on 18/8/2021, which
Revised by whom?
award, my lord,
Revised by whom?
revised by the Kala.
After the award is being made.
My lord, that's the whole, my lord, under the misconception of fact, my lord, the court as well as the advocate were proceeding, my lord, as if, my lord, those are the award. But in fact, it is not an award. We have also, my lord, failed to, my lord, produce certain documents, including the manual, which provides, my lord, the detailed procedure how to, my lord, the acquisition under the act is to be done, which is followed across the, my lord, country. And some more documents to show that this was not an award. Even on the face of the, this letter, particular, 17/4/21, as well as 18/8/2021, it would appear, it doesn't have the characteristics of an order or an award.
So you mean to say,
In fact, my lord, what happened here, my lord, for the entire stretch, my lord, the objections, my lord, were received about, the benefit claims were about 625 or so many. Now, so far as undisputed claims were there, about 264 cases, there the award was passed. That is an award. That is an award in respect of 264 cases, and remaining claims, it was opined that it will be, my lord, in part 2, part 3, etc. So,
have you taken the possession?
my lord,
Have you taken the possession?
possession has been taken.
How?
My lord, we have deposited the entire amount, my lord.
Before?
Before the Kala, we have deposited.
So you deposited.
And in fact, they have also disbursed the writ petitioners, they have also received it.
No, no. Has the petitioner got those amounts?
Yes, yes.
Then why you are filing the review?
But here, 17/4, the first which was said to be an award, there some components were included which are not permissible under the law. So with the NHIDCL under the manual, they have a right to object to this estimate. This is not at the stage of award. This is towards the process of determining the price of the land value, etc.
Then why did you make the payment?
So we have submitted our objection. Then the Kala has revised it because it was an estimate. Then it has revised by the letter dated 18/8/2021, and this was approved by us. So therefore, we made the payment. But so far as the first one is concerned of 17/4/21, we did not approve nor we have paid for it. Subsequently, after the 18, we have paid entire amount. We have approved. We have paid the entire amount. And
So you have paid as per?
As per the 18/8/2021.
18/8/2021.
20.
Where is that document?
Hmm. 101. I'll just put that.
So you have paid this amount,
We have paid,
this amount of 25 crores.
Lordship,
You have paid this.
paid this, we have paid.
So let us see the earlier one, which was approved 17/4,
17.4, my lord, will find at page 73.
page 73.
73. It's an estimate that has been submitted seeking approval so that award can be passed as per the my lord manual.
Thereafter, what has happened?
My lord, thereafter this having been passed, my lord, we have submitted our objection, page 89. Before that, may I take your lordship to the provisions of the manual by which we are, my lord, supposed to, my lord, point out the deficiency, whatever appearing in the determination.
So here you say number 4 at page 90. It is therefore requested to assess only the cost of the land, that is without the cost of the stone, and submit the revised estimate.
Lordship,
Now, in pursuance to that, he has submitted on 18/8.
18.8. This problem had been faced by other district also.
How do you say that the 18/8 is the award?
My lord, we say, my lord, it is also
This
not
is
an-
also the same
this is
document.
also same. It is also not an award, my lord. In fact, the award, that additional document, my lord, will find.
Then how did you take over possession?
My lord,
How did you take over possession?
because payment have already been given, my lord.
Payment how? How have you made the payment?
It-
Mr. Saikia, we are concerned with out here. As a provisions, your manual would not have any impact unless you followed the provisions of the National Highways Act. Kindly see 3H1.
But
See,
this 3G also speaks of an order, my lord.
let us not go into 3G. First, let us go to 3H1.
Lordship. The amount determined under section 3G shall be deposited by the central government in such manner as may be laid down by rules made in this behalf by that government with the competent authority before taking possession of the land.
So you are to deposit this money so and so. Now, if you say, when did you deposit?
My lord, immediately after this, my lord, 18.8 order, my lord. Immediately after the.
Where is the award then? If this is not the award you are saying.
It's remained to be, my lord, it is the, within the domain of the Kala, but since, my lord, there is an urgency.
No, therefore,
We have,
if we go by your submission, 3G1 has not been complied with. 3G1, because there is no award,
no award.
and 3H1 cannot be complied without the 3G1. So therefore, you can't take over the possession.
But this speaks of the, my lord, determination, since, my lord,
If you say that there is no determination, because tomorrow we say that it is 18/8, but what is the difference between 17/4 and 18/8?
because we have approved it. We have approved, central government has approved it.
I'm not concerned with the central government. How can the central government say that they are going to approve? Isn't the Kala given a particular offer, the mandate out there as per 3G3? See 3G4, 3G3 or 3G4? Isn't that the mandate of deciding?
Before it proceeds.
Meaning thereby, are you saying that the Kala will only hear what the central government says? Is this the manner by which put it on affidavit? Then we think then the central government, I think, is wrong.
Yes, my lord, that's what, my lord, we have been saying, my lord, this, there's no rule as such, my lord, frame under this, my lord. Then, my lord, this ministry guidelines has been, my lord, formulated.
We have to go, forget about the ministry guidelines. First, you have to go as per 3G3.
Got you, my lord. My lord,
3G3 is giving objections.
yes, ma'am.
So you give your objections. Let us assume that you have given your objections on 21.5, and thereupon he has come up with this thing.
18.
But where is it? Where is the award? And without the award, without that award, nobody can go under 3G. 3G5, one can go only after an award.
Got you.
So therefore, there is no award as of now.
As of now, there is no error.
So if there is no award, how did you take possession? How did you deposit any amount?
After publication of the my lord, this 3D notice, my lord, it vests with the my lord, the property vests with the my lord, central government.
It
Then, my
will
lord,
vest.
upon determination,
It will vest.
got you.
But the question is, how do you take over the possession? The title vests.
Got you.
But how do you take over the possession? The possession takes over only in terms with after depositing the amount. But you can only deposit after 3G1 is done.
But that was my lord, the whole thing, my lord, because the
So I think you better
central government,
return the land back to these people. Return the land back to these people. This is how things will improve then. This is not the way you are going to, whatever you feel like you are doing it.
now see, my lord, the determination, my lord, first determination was made by letter dated 17/4/21. We had submitted an objection.
Then why on earth you did not mention about this 18.8 before the single judge or before us?
That's what, my lord, mistake of fact, my lord, that has been, my lord, done by the parties concerned and also, my lord, the
Party concern means you were duly represented. You have filed an appeal.
My lord,
Then
the best authority would have been, my lord, the
even
Kala.
in the appeal, this was not done.
State
Now,
state
if it
government
is a
would have been-
case of review, we have to go by what? Review, we have to go by what? Due diligence?
Yes.
Where is your due diligence?
This, my lord, state government, my lord, the Kala, my lord, which represent, my lord, the Kala also, my lord. So, my lord, it was, my lord, they ought to have come up, my lord.
No, you
since,
filed
my
the
lord, they-
appeal. Remember? You filed the appeal. Isn't it?
Read appeal, my lord.
Yes.
Lodge.
If you filed the writ appeal, so therefore, it was your duty to place it.
That was, my lord,
Where is your due diligence?
lodge. That is, my lord, the things, my lord, and we could not, my lord, place this manual as well as the documents which now I have, my lord, from page 89 onwards. This could not be deposited.
Where is the
But
award?
thereby your lordship will kindly see the entire public interest, my lord, what is happening here now. The minerals underneath, my lord, that has been assessed, which is barred under the, my lord, Mizoram Act also, as well as, my lord, this manual does not, my lord, incorporate that component that anything under the earth will also be assessed to the, my lord, this while determining the my lord, price. So this 17.7 contain this aspect. So that was objected, my lord. And now without that component, they have, my lord, come up, my lord. And it is not only the, my lord, this situation is faced by this district, my lord, the other, my lord, Kharjal district also faced with the same problem. They have also written to the, my lord, state government. And therefore the state government come up with the, my lord, notification dated 13/8, saying that under the act is, my lord, is barred.
Let us come to page 75. Where is the amount which you are saying that it is being included? You're saying about the minerals, where is it mentioned?
My lord, this page 74 total amount that has been given 53.
I'm not on that.
Got
The
you.
assessment is at page 75.
Got you, my lord.
And why have you put only solicium of 18% or something? What is this business of solution? 18% or 100%? Kindly
100%, my lords.
Land rate per hectare, so and so, land value, 2,62,842. Coliseum, 62,480. I think that is 100%. Period of interest, so and so. Where is the land? Land is where? Where is the multiplication? As per 26.2. Thing is there. And where is that in this 18A, where, how they have put it? What is the difference between 75 and 102? It appears to be the same.
Verify it, I have to seek instruction on this.
Without anything before the court, and now you are asking for review. And what are your grounds taken in the review petition is this, that if you go for 3G5, if the amount is reduced, then how can you recover it from these people? Isn't that the ground?
That is, because of the public interest that is involved,
No, we are concerned with paragraph 16, wherein you say that. Now the question is, that means are you admitting that there is a award, that is an award? Without an award, you cannot go under 3G5. So on one hand, you are saying that there is no award. One hand, you are saying that there is an award. Which one is to believe?
As this, the Honorable Single Judge as well as your Lordship, in Division Bench has helped, termed it as an award. We had also, gone to the apex court. Then, an observation was made, for filing an modification order before this court. And accordingly, the
Where is that order?
SLP has been withdrawn. Page 149. Appliance of this novel coach order, we have preferred that arbitration application as well.
Okay, we issue notice on your application for application, but you have to come up with what is an award. Without that, we are going to dismiss it with your review, because you have not. There is no due diligence. Yes.
We have also filed one IA, though
For what?
period is not prescribed, filing the review petition against the this appellate judgment, writ appeal order, judgment. still, my lord, we have, presuming it to be 30 days, we have filed a IR for condemnation of the bill.
There's a condemnation is required.
No, it is, otherwise, my lord, perhaps is not required, but it has
Why?
been filed. It is,
You are referring to the 63 judgment of the Supreme Court. In 226, there is no requirement.
my lord, that is
But
there.
how do you take care of a writ appeal? This is an intra-court appeal. Then 63 judgment is on the question of another
The
aspect.
High Court rules also, my lord, prescribes 30 days for the purpose of, my lord, the writ appeal. But so far as the review is concerned, my lord, chapter 10, my lord, it has not mentioned any such, my lord, date. Nor it says, my lord, the chapter 5 yet to be followed, my lord. So, but nonetheless, we have filed this, my lord, application, my lord, condemnation review. So notice on
No,
that
the
also.
review you have filed, normally in a writ petition, if it is passed against a person who is not a party, then he can very well come before the court and seek a review even without an application. Because there is the question of limitation does not come. But we are concerned out here where you had filed an appeal. That appeal was not only dismissed, there were directions being passed. Against that, you went to the Supreme Court. The Supreme Court on 17 to 2025 granted you the liberty. And you filed this when?
It was on 27/3.
27/3. So then also 1 month is over.
We have explained that, my lord, in the IR.
You know?
That
You
can
notice
be
making it returnable by making it returnable by 16th June. Because the address which you have given, you can never serve it.
Yes, 16 June. Yes, those are there.
Resident of Chatlang. This is such a small area. Notice those steps being taken upon the respondents by way of registered as well as usual. Anybody appearing for the government there?
None, my lord.
There is no government counsel.
They are on legs, my lord.
They are all on legs.
Yes, it seems, my lord.
Liberty, however, is given to the petitioner, the review petitioners to take steps upon the counsel who represented
Hmm.
the respondents, the private respondents
Hmm.
in the appellate proceedings. This court further grants liberty to the review petitioners to serve copies of the instant application upon the do you have a senior government advocate?
My lords, yes.
Upon the senior government advocate insofar as the respondent numbers 7, 8, and 9.
Principal seat,
Master approval में
Secretary item 18, personal appearance through VC.
Okay.
Yes, sir, for ASTC lordship. Lordship, so far as your lordship last direction is concerned,
My
lordship.
lord, the MD ASTC is present through video conference and learned additional advocate general is present physically there.
Right now, he is at Palasbury, lordship, busy in election duty, but however, he is connected with online lordship. He is present for. So far as first issue is concerned.
Learned additional this is not audible to us, my lord.
Some connectivity problem is there now. But so far as first issue, lordship, payment of 5 lakhs rupees is concerned, lordship, we are holding a stake, lordship, for that amount, lordship. So, first issue has already been addressed. So far as the second issue is concerned, lordship, as your lordship is aware, election is going on. So I am praying at least 2 weeks times, lordship. We are pursuing with the matter, lordship. We need approval of the higher authority. We are positively considering, and I hope, lordship, within 2 weeks time we'll be able to convey something positive in this regard.
Regarding?
Lordship,
Regarding?
regarding handing over of vacant possession of the land.
We give the check to him.
Yeah, but only one, this is dated 23/5, lordship. So in our estimation, lordship, by that date, lordship, that amount will be there in our account, lordship. That much I am submitting. It is dated, lordship. Pre-dated.
23/5.
Yes, sir.
It's okay. Take it. We'll record it in the order.
So lordship will record my submission, lordship. In the meantime, we are handing over.
I call Lakoka. I will close it as not pressed. As the managing director is present through the video
Yes, he's
conferencing,
present,
this is what has been asked for. What else, what additional modification you require in the IA? You don't require any.
IA is actually infructuous, my lord. IA that was filed.
Mr. P. Nayak, the learned counsel, appearing on behalf of the petitioner, applicant, and Mr. DCC Pukon, the learned counsel, appearing on behalf of the respondent, The managing director of the ASTC is present before this court through the video conferencing mode. So taking into account nothing remains in the instant application for which the application stands closed. Main Konot Mr. and the presence of Mr. So-and-so, the managing director of the ASTC, is dispensed with. Yes, you are the managing director?
Yes, my lord.
Mr. Somu
My lord.
did not be there. Remove. Mr. Managing Director, when you give an
My lord.
application before the court, it has to be an unequivocal undertaking. It cannot be an undertaking by which you say that you have given it for yourself. You are representing the ASTC before these proceedings. So therefore, it has to be on the basis of an authority being given by the ASTC. Otherwise, you cannot give an undertaking. The undertaking which you gave by way of an affidavit. This is the most vital aspect. Secondly, most pertinent out here, that this court have taken a view that the application which you have filed under Article 227 challenging the order of the learned district judge or the land grabbing tribunal is not wrong. Therefore, however, if I pass an order in 227 out here dismissing your application, it will entail criminal consequences upon you because criminal proceedings will be initiated against the managing director as well as all the other employees of the ASTC. Therefore, I said that why not take up a thing as you are a government authority? Why not vacate the land and put that rest the entire proceedings before this court. So that is the reason why it was being done. But it seemed that your ASTC had taken it in a more adversarial manner. Mr. Naik, appreciate that.
Yes, Lordship.
The reason is there is no infirmity in the order passed by the learned land grabbing tribunal. What is there, therefore, I didn't want, because once I dismissed this petition, the next consequence is the criminal proceedings under the land grabbing
I
tribunal,
understand.
by which government officials who are manning the ASTC would be in more trouble, because they will be then rendered as accused, which will have an impact. Tomorrow, the managing director, who may be a bureaucrat, he will have a problem everywhere. He has to mention out there that there is a case pending against him. These are criminal consequences of different aspects which cannot be taken with a civil consequence. So therefore, that was the reason why I have asked, when are you going to vacate? When are you going to make the payment? So that the thing can be put at rest.
Lordship.
That is the basic idea. But if you want to go for an adversarial, this court has no problem in dismissing your
Lordship,
petition,
I'm on.
which will have an impact upon everybody, because
Lordship,
then the criminal proceedings will go on.
Lordship, at this stage, I'm only praying for 2 weeks' time, Lordship. Lordship will take up this issue on the next day.
Mr. P. Naik, the learned counsel, appears on behalf of the ASTC, appears on behalf of the petitioners in the instant proceedings, and Mr. DCC Pukon, the learned counsel, appears on behalf of the respondents. So during the course of the hearing, Mr. P. Naik had handed over a check. Give me the check. Name.
Check.
Umesh Chandra Deka.
Put the name.
Umesh Chandra Deka.
Put the name.
Lordship, he will only submit the necessary documents like PAN card, etc. Lordship. PAN card, bank statement, etc.
Bank statement, why required?
Lordship, for deduction or something else. Lordship.
There is no deduction.
Account is saying, Lordship. Account is saying.
No, there cannot be any deduction. This is the compensation to be paid. There is no question of deduction.
नाम तो लिखा ना? नाम तो लिख दिया।
Where is the name?
Yeah, language. No. Only language. Okay.
Umesh Chandra Deka.
15 to full के लिखा है।
The course of the proceedings, Mr. P. Naik, the learned counsel appearing on behalf of the petitioner, have handed over a check of an amount of rupees 6,85,918, being the amount being the compensation as
9%.
being the compensation adjudged by the learned presiding officer, Special Tribunal Land Grabbing, Morigaon, in Sessions Special Land Grabbing Case Number 02/2014, dated 18/3/2021, which includes the interest at the rate of 9%. Mr. Naik submits that the check is dated 23/05/2025 check to number two. The said check is drawn on State Bank of India, bearing check number 279977 in favor of the respondent hearing. Mr. P. Naik, the learned counsel submits that the check has been drawn on 23/05/2025 on the ground that at present the said account does not have the said amount. However, he submits that the STC shall ensure, the petitioner shall ensure that the amount written in the check is available on the date of would be available on 23/05/2025. Also, the check during the course of the hearing is being handed over to Mr. DCC Fukun as a full and final settlement towards the claim of compensation in terms with paragraph 51 Roman 3 of the judgment of the impugned judgment and order dated 18/3/2021. Full stop. Mr. P. Naik further submits that as regards the delivery of vacant possession, taking into account the ongoing panchayat elections, some time may be granted so that he may so that appropriate submissions can be made in that regard. List this matter again on 10th of June 2025 at the top of the list.
My lord, may I pray for the dispensation of personal appearance of the MD?
Mr. Naik, didn't I pass an order earlier?
I heard.
Your other counsel who is sitting out there seems to be
Lordship is
overzealous.
not audible to them, actually, that is the.
Now the mention hour.
Right, sir.
Yes.
Lordship, I apologize for mention item number 12. Lordship, in this matter, my senior can show you due to some unavoidable circumstances, he is out of town, Lordship.
Who?
My senior can show you, Lordship. Lordship, kindly
Madam,
accommodate.
let me tell you one thing. I do not adjourn on the ground of senior counsels. You must be aware. No adjournment on senior counsel. Hope and expect the matter does not reach.
Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 15 for upgradation, Lordship. On
1-5.
Yes, Lordship.
Why?
On last occasion, Your Lordship has given liberty to upgrade the matter, Lordship. If Your Lordship permits, can
3
you
o'clock.
please?
Top of the list, item 1.
Yes. Did you find anything?
To be very frank, I couldn't find. I made some searches, but one argument I want to make, as your lordship has seen, my lord, possibly your lordship was indicating that how to declare a gift deed to be a sale deed. To that effect, it's very difficult. I have made some research. Directly, there is nothing. But whether, my lord, one issue will arise in view of the facts and circumstances of this case, that in view of the fact that three things are there. One, the agreement is still existing. He has not prayed for declaration that the agreement itself is bad. No declaration with regard to the agreement, meaning thereby that he doesn't want to disturb the agreement. So his intention to sell in terms of the agreement remains. This is number one. Number two, my lord, your lordship will see from the prayer, he is not praying that the advance amount, which is not a very, well, earnest money, it is an advance amount, more about 50%. That amount he will refund. No decree of this nature is sought. This is second, my lord. And thirdly, my lord, in the cross exemption, when he says that in respect of the other pro forma defendants to whom I have ultimately executed a gift deed instead of a sale deed, I have not objected because I have received the full amount of consideration. So, my lord, then, my lord, he is not disputing his signature. He is not disputing the fact that he has intention to sell the land. His only grievance is that he has not received the balance amount, although we have pleaded that we have paid the balance amount also.
The deeds which were executed in favor of the defend numbers, performer defend number 3 to 9,
My lord.
were also give deeds.
My lord. So, my lord, my submission is subject to your lordship's consideration, my lord. In view of all these facts and the prayer made in the plaint, the present suit is not maintainable. It will be maintainable subject to, my lord, what your lordship ultimately say and subject to what my learned friend argues. The suit will be maintainable only when, in terms of 55 4B, of the Transfer of Property Act, if he amends the plain and says that I am entitled to receive the remaining amount of consideration, number one, and number two, although the gift deed, he never executed the gift deed, he executed the sale deed, my lord. It is his stand. So if he prays for a decree that this gift deed may be declared to be a sale deed and the remaining amount of money may be directed to be paid to me, this suit in that event will be maintainable, and in such a situation, my lord, this honorable court will be in a position to exercise the power under the provisions of the 55(4)(b). This is how possibly, my lord, subject to one solution is like that. And there is another aspect of the matter, my lord. He has prayed for a decree of declaration of title and confirmation of possession. Now, my lord, admittedly, he is not in possession of the land. He has admitted in the cross-examination, not only the plaintiff, another witness examined by the plaintiff, that possession was duly delivered to the defendant and the defendant are in fact in possession of the land. And there is no prayer for recovery of possession. So in view of section 34, proviso to section 34 of the Specific Relief Act, I'll say, my lord, there are two judgments I'll refer to. One is by...
Mr. Mazumdar, the question is, did you raise these issues before the trial court?
My lord, your lordship will be absolutely correct. This
So if you can't raise issue, this can't be a substantial question of law.
My lord, what I am saying is, my lord, in view of that recent judgment of, my lord, that Honorable Justice Datta, I possibly, lordship can raise this issue if the suit is not maintainable.
Why?
That there is no prayer for realization, recovery of possession.
Why?
Only prayer is a declaration of title. This is my second submission, my lord. If your lordship says that in the first submission which I have made.
The law as regards the proviso to section 34 was developed by the judgment of the Supreme Court in 1961, wherein it also mentioned that you have to raise this in your written statement.
I'll rely on the recent judgment where this says if the suit is otherwise not maintainable, possibly your lordship, the court can also say that no, if the suit is not maintainable, we will examine that.
It can be done so in a second appeal without, can that be a substantial question of law?
If your lordship can raise this.
Why should I raise it?
Now, if the court doesn't examine, then matter is different.
What do you say about paragraph 15 of Santosh Hazre's judgment? It says, a substantial question of law will only arise when it is based upon pleadings as well as issues framed and determinations so made by the courts below.
We have not raised, in the written statement possibly we have not raised.
Nothing has been done. Why should it be a substantial question of law? Because it has to be a substantial question of law involved in the instant appeal.
This point was not raised, I am raising for the first. This point was not raised. So, well, my submission will be present suit as framed on the first point, my lord, which I have. Second suit, your point, your lordship is not appreciating. So, for the first point which I am trying to develop, my lord, the present suit in the present form will not be maintainable unless they amend the plea. Because they themselves have made it very clear that they have got intention to sell. Their only grievance is that they have not received the remaining amount of consideration money. So, in that view,
Mr. Mazumdar, why you are not arguing on the point which I have formulated?
But at that point only I am arguing on 54(b), my lord. 55(4)(b).
Why was 55(4)(b) brought into the picture by this court?
Because, my lord, in the
The
case
reason is very specific.
my lord,
The plaintiff says in his plaint, look here, I had entered into an agreement with the defendant number 1 and 2 as well as the defendant numbers 4 to 8 in respect to a plot of land which he had measured something 22 bighas. The agreement with the defendant number 1 and 2 was they are going to pay me 96,000, of which they have duly paid me 55,000.
yes.
The question was as regards payment of 41,000. So I have taken the permission and asked them to make the said deeds. When these deeds were being made, I signed it. Later on, when I asked them the 41,000, they say that you have made the gift deed. Where is the question of making of 41,000?
Correct.
That is the case.
That is
Is the actual cause of action.
His actual cause of action is that he has not received the balance amount.
Amount.
Well, that is why I'm
So
saying, my lord.
therefore I am saying,
My lord.
whether it is no, the intention of the parties was always a sale deed.
Absolutely.
So if that is a sale deed, so the gift deed, whether has to be read as a sale deed,
Right.
taking into account that it is it is the intention of the parties when they were entering. Whether you put it in the gift deed as gift deed or the sale deed or whatever may be, the question doesn't differ out there. Because it is based upon a consideration which is one required, and it was partly promised and partly done, partly paid.
My lord.
So therefore, it was promised 41,000. So that amount has been duly made. Now, what is written? What is the covenants out there in the gift deed which has been mentioned out there is actually, if you see the plaint,
Right.
it is actually a sale deed.
My lord, that is why I'm obliged, my
It is
lord.
he who have stated
I'm,
that.
I'm deeply obliged, my lord.
So
What
it
I'm-
is not a question that this court needs to declare it,
Right.
that it is a sale deed. No. What this court is required to do is to read the say document as a sale deed, taking into account that the intention of the parties behind it. Isn't that the judgment of Justice Sagir Ahmed in that regard?
My lord.
99?
The other day, my lord, judgment, Vidyadhar's case, my lord. Vidyadhar, 99 3.
Sagir Ahmed, Justice Sagir
Yes.
Ahmed judgment. Yes, Sagir Ahmed.
My lord,
99 3 and
Yes.
65.
Yes. Para 48, Lordship of time. The basic principle is that the form of transaction is not the final test. Lordship is correct. And the true test is the intention of the parties in entering into the transaction. That in the position where he himself is saying that I went there and I put my signature,
That is his statement in the plaint.
my lord.
You don't need any other evidence. That is his specific case. That look here, when I went out there, they were saying that where are you? What 41,000? You have gifted the land. Where is the question of making payment? Yes, Mr. Kaur.
So for one fact that has just struck my ear of my friend is that the other two deeds were also gifted. It is not. The first appellate court and the trial court has come to a finding that those are, the other two are sale deed and possession has been delivered. So far, my friend clients are concerned, to them possession has not been delivered. And one of the most important ingredients, subject to correction of my lord, that so far 55(4) of the TP Act is concerned, if your lordship looks into 55(4)(b), the possession has to be delivered. And in this case, possession has not been delivered. Unless possession, this is a protection given to the seller when possession is delivered. And in this case, possession has not been delivered. So 55(4)(b) will not be applicable so far this case is concerned. Your lordship is look into 55(4)(b). Probably your lordship has read it. Your lordship will find at the last 4 words, this 55(4)(b) will be applicable only when possession has been delivered. So your lordship has formulated the question on 18(3) order. And if your lordship looks into the trial court judgment and the appellate court judgment also, it is categorically held that possession of the suit land by defendant number 1 and 2 is also not clearly proved, and which has also been upheld by the first appellate court. Now, if your lordships looks into the plain, what was our contention in the plain?
Where is, Mr. Mazumdar, you are saying that possession has been delivered
My lord, I have to show from the admission of the PW1 and PW2.
of the
PW1 and PW2.
PW1, tell me where?
My lord, I'm just reading.
Who is Dinanath Barua? You are.
Yes, he is the one of the person.
No, you are. What is your name?
My lord, I am the Dinanath Barua plaintiff. Noni Barua is, his, and Mukul Hazarika and Noni Barua is by my friend. Dinanath Barua is me, my lord, the plaintiff. Now, since this is, my lord, legal LR has been substituted.
Well, may I read from PW1's
Yes.
clauses? It is possibly internal page 12 of the deposition of PW1 from the record.
Read it.
Page 12, bottom, I know the last word, baki. Page 12, last word, last line.
Badi.
Badi. Badi, বাকি, it's বাকি নেই। বাকি খরিদাৰৰ গণেও দান দলিল বুলি পিছতহে জানিব পাৰে। গোচৰীয় জমিৰ দখল দিয়া সময়ত মই যোৱা নাছিলো। মোৰ কামলা জালালুদ্দিন মোৰ হৈ জমিৰ দখল দিছে। It is PW1 himself, my lord. Dinanath Barua. Now, he says, my Kamla delivered possession. Kamla was examined. Kamla is PW2.
So far, the person caretaker is
Kamla's-
concerned,
Let-
the
let-
caretaker, yes.
Kamla's evidence, my lord, deposition, page 2. Page 2, if your lordship has got, my lord. Line about 7th or 8th from bottom. Bikri kora jomi, lordship has got, my lord. Bikri kora jomir dokhol. Badir সম্মুখতে মই, বাদিৰ সম্মুখতে মই সমঝাই দিওঁ, বাকি থকা ইমান জমিত মই এতিয়াও খেতি বাৰী আছো। So he says, I have delivered possession in the presence of the
Let us read from before.
my lord.
Where, yeah. Because you see,
My lord.
when he says
My lord.
remaining 12 bighas, I am still in possession.
Yes. What is that?
Meaning thereby,
Yes.
it is a 22 bigha plot.
Yes.
22 bigha and the 12 bigha is of the plaintiff,
Yes.
of the
Of the
defendant
defendant.
number 1 and 2.
Yes.
So that, let us see therefore, to
Yes.
read it. Let us read the entire one.
Yes.
My body,
Your lordship is reading from,
from the first one, PW1, PW2.
Two, my lord.
PW2.
Hmm.
Your,
My body,
মই
Yes.
বাদী বিবাদী উভয়ে চিনো বাদীৰ যোৱা 20 বছৰ আগৰ পৰা কৰিব পাৰিবানে?
Sinu.
your lordship will see, বাকি থকা 12 বিঘা 3 কঠা 15 লেচা জমিত মই এতিয়াও খেতি কৰি আছো. This is the land which they
That
said.
is why, that is why I
Yes.
asked him.
Yeah. Your lordship will read it from a little ahead, my lord. Your lordship will read it from first. I will read. মই বাদী বিবাদী উভয়কে চিনো। বাদীক যোৱা 20 বছৰৰ আগৰ পৰা চিনো। তেওঁ চাহ বাগানত চাকৰি কৰিছিল। মোৰ ঘৰৰ পৰা উক্ত বাগান প্ৰায় 2.5 মাইল দূৰত। পমিলা জাননী গাঁৱত থকা বাদীৰ জমিত মই খেতি কৰিছিলো। তাত বাদীৰ 22 বিঘা তিনি কঠা 15 লেচা মাটি আছে। এই মাটি পমিলা জাৰণী আৰু চিতলমাৰী কিচামত গৰুবাট মৌজাৰ অন্তৰ্গত। উক্ত গোটেই মাটিখিনি এই চৌহদতে অৱস্থিত। এই 22 বিঘা 3 কঠা 15 লেচা জমি উত্তৰে চৰকাৰী ৰাস্তা, দক্ষিণে হেলিম, পূবে ৰফিক আৰু পশ্চিমে চালাম। পূবে ৰফিকৰ লগত অনিলো আছে। মই উক্ত জমি বাদীৰ পৰা 20 বছৰ আগেই মাহে 1000 টকা দৰমহা বন্দবস্ত খেতি কৰোঁ আৰু পাছত বিঘাই 3 মোন ধান দিয়াৰ চুক্তি বন্দবস্ত খেতি কৰোঁ। চুক্তি বন্দবস্ত খেতি কৰা 12-13 বছৰ হ'ল। গুচৰীয়া মাটিত খেৰী ঘৰ 3টা আছে। এই ঘৰত মই থাকোঁ। এটা ঘৰ পাকঘৰ আৰু আনটো গোহালি ঘৰ। ইয়াৰ বাদেও অন্য কাৰো ঘৰ নাই। এই ঘৰ পমিলা জাৰণী কিচামতৰ মাটিত আছে। এই জমিত শালি ধানৰ খেতি হয়, দৌ বাম মাটি। এই মাটিৰ পৰা প্ৰায় 10 বিঘা মাটি বাদীয়ে বিক্ৰী কৰে। বাদীয়ে লক্ষীৰাম, হৰেণ, বীৰেণ, দুলেন আৰু জীৱনক বিক্ৰী কৰে প্ৰায় 2 বছৰ আগতে। বাদীৰ পৰা আৰু লক্ষীৰামৰ হাতৰ পৰা মাটি বিক্ৰী কৰাৰ কথা জানো। বিক্ৰী কৰা জমিৰ দখল বাদীৰ হুকুম মতে মই সমজাই দিওঁ। বাকী থকা আদাৰ টু দে হেভ হেণ্ডেড। বাকী থকা 12 বিঘা 3 কঠা 15 লেচা জমিত মই এতিয়াও খেতি কৰি আছোঁ। যোৱা বছৰ খেতি কৰি পানীয়ে নষ্ট কৰে। 10 মোন ধান বাদ দি দিওঁ। তাৰ আগৰ বছৰো ময়ো খেতি কৰোঁ। ননী বৰুৱা, মুকুল হাজৰিকাক চিনো। মুকুলৰ ঘৰ বিবাদীয়ে জমিৰ পৰা 2.5 মাইল দূৰত। তেওঁ নগাঁও পানীগড়ত থাকে। মুকুলে মাটিৰ দখল বিচাৰি গৈছিল। মালিকে নোকোৱাৰ বাবে দখল এৰি নিদিওঁ বুলি কোৱাত মুকুলে ঘূৰি আহে। So this position was never handed over to them. Now your lordship will look at PW1. I will read those.
Let us read the cross also.
Yes, sir. I'll read it completed, my lord. এই মাটিত পুলিচ যোৱা নাই। এই গোচৰৰ বাদে আন গোচৰ হৈছে যদিও মই নাজানো। উক্ত জমিত বাৰিষা পানী হয়, তাত বাৰী নাই। বাৰিষা পানী হ'লেও আমি ৰাস্তাত আহিব লাগে। লক্ষীৰাম, হৰেণ, জীৱনহঁতক মাটি বিক্ৰী কৰা সময়ত মই কামপুৰৰ চাব ৰেজিষ্ট্ৰাৰ অফিচত আছিলোঁ। সিদিনা অৰ্থাৎ দলিল কৰা দিনা মুকুলো ননীক মাটি সমজাই দিবলৈ বাদীয়ে মোক কোৱা নাছিল। এইবাৰ খেতি ময়ে কৰোঁ। বাদীয়ে ক'লে মই উক্ত জমিৰ পৰা উঠি যাম। মোক এতিয়ালৈকে বাদীয়ে উঠি যাব কোৱা নাই। নাও দ্য ক্ৰছ মালত। এই মাটিৰ মাজেদি এটা জান আছে। তাত খৰালি পানী নাথাকে। মোৰ ঘৰৰ পৰা এই জানটোলৈ প্ৰায় 10 নল মান দূৰ। হিমা, ৰফিক, চালাম, হেলিম আদি বৰ্তমান জীৱিত। তেওঁলোকে দখল কৰি থকা মাটি ম্যাদী নে চৰকাৰী মই নাজানো। মোৰ লগত বন্দবস্তি লিখা পঢ়া হোৱা নাছিল। বাগানত মই আগতেই নলা খান্দা কাম কৰোঁতে তেতিয়া বন্দবস্ত হৈছিল। যেতিয়া মোৰ লগত জয়নালো আছিল, দৰমহা মই মাহে মাহে বাদীৰ পৰা আনো আৰু খেতিৰ শস্য সম্পূৰ্ণ বাদীয়ে লয়। এই বছৰ মই 10 মোন ধান আঘোণ মাহত বাদীক দিওঁ। 10-15 তাৰিখে মানে দিওঁ। মই 30 মোন ধান পাইছিলোঁ সেই বছৰ। বাদীয়ে এতিয়াও টাউনত থাকে আৰু মাজে মাজে মাটি লৈ যায়। 10 মোন ধানটো মই বজাৰত নি বিক্ৰী কৰি 1500 টকা মই বাদীক ঘৰত দি যাওঁ। এই গোচৰটো দিননাতে কাৰ বিৰুদ্ধে কিয় দিয়ে মই নাজানো। পামিলাজাৰীত 2 বিঘা 3 কঠা মাটি আছে। এই 2 বিঘা 3 কঠাৰ উত্তৰ ফালে ভাল ৰাস্তাৰ দক্ষিণে বাদীৰ, পূবে হৰেণ আৰু পশ্চিমে চালাম।
Then come back.
Yes. এই গোচৰটো দিননাত কাৰ বিৰুদ্ধে কিয় দিয়ে মই নাজানো। পমিজালত 2 বিঘা 3 কঠা মাটি আছে। এই 2 বিঘা 3 কঠা উত্তৰ ফালে ভাল ৰাস্তাৰ দক্ষিণে বাদীৰ, পূবে হৰেণ আৰু পশ্চিমে চালাম। চিতলমাৰীত 9 বিঘা 2 কঠা জমি। এই 9 বিঘা 2 কঠাৰ উত্তৰে চৰকাৰী জান, দক্ষিণে অইন এটা জান, পূবে ৰফিক আৰু পশ্চিমে চালাম। মোৰ ঘৰ পমিলা জাননী মাটিতে। ওচৰতে অৰ্থাৎ 4 নল মান আঁতৰত চালামৰ ঘৰ। এই মাটিত দাগ 4টা, কিন্তু নম্বৰ নাজানো। পট্টা নম্বৰো নাজানো। মই খেতি কৰাৰ আগতে উক্ত মাটি খেতি মাটি আছিল আৰু কাবেদ আলীয়ে খেতি কৰিছিল। কাবেদ আলী বৰ্তমান জীৱিত। দলিল কৰাৰ দিনা লক্ষীৰামে মোক কোৱাত মই পিছত আহোঁ। মুকুল, ননী বৰুৱা, হৰেণ, উজ্জ্বল আদি সকলো দলিল কৰাৰ দিনা ৰেজিষ্ট্ৰাৰ অফিচত উপস্থিত আছিল। মুঠ কেইখন দলিল হয় নাজানো। মুকুল আৰু ননীক কিমান মাটি বিক্ৰী কৰে মই নাজানো। লক্ষীৰাম 3 বিঘা, হৰেণক 2 বিঘা, বীৰেণক 2 বিঘা, দুলন আৰু জীৱনক 2 বিঘা মাটি বিক্ৰী কৰে। জমি বিক্ৰী কৰাৰ পিছত শাওণ মাহত মই দখল সমজি দিওঁ। দিননাথে তেতিয়া উপস্থিত নাছিল। মুকুলে মাটি দখল কৰিবলৈ কেতিয়াও যোৱা নাছিল। মুকুলৰ ভাই ককাই 4 জন। পমিলাজনীৰ ৰাস্তাৰ কাষত তেওঁলোকৰ থকা ঘৰ আছে। মই খেতিহে কৰোঁ, গৰু ব্যৱসায় নকৰোঁ। বিক্ৰী বন্দোবস্ত হোৱা সময়ত বাদীয়ে মোক কৈছিল। বন্দোবস্ত ক'ত হয় মই নাজানো। মাটি গোটেইখিনি বিক্ৰী বন্দোবস্ত হোৱা বুলি মোক কৈছিল। বিঘাই প্ৰতি 8000 টকা দামত বন্দোবস্ত হৈছিল। কাৰ কাৰ লগত বন্দোবস্ত হৈছিল মই সোধা নাই আৰু বাদীয়ে মোক কোৱাও নাছিল। দলিল কৰা 1-1.5 মাহ মান আগে বাদীয়ে মোক কৈছিল বিক্ৰী বন্দোবস্তৰ কথা। দুটা ঘৰ মই বনাই লওঁ প্ৰায় 8-10 বছৰ আগে। এই ঘৰ আগৰ পৰাই আছিল। তাত মোৰ আগে কাবেদালি আছিল। সেই ঘৰ এতিয়াও আছে। মুকুলহঁতৰ বাদে বাকী কেইজনে সেই মাটিত খেতি কৰি দখল কৰি আছে। আদাৰ দেন মুকুল। বিক্ৰী দলিল কৰাৰ 2 মাহ মানৰ পাছত বাদীয়ে মোক দখল চমজাই দিব কৈছিল। বাদীয়ে কোৱা 4-5 দিন পিছত মই দখল চমজাই দিওঁ লক্ষীৰামহঁতক। মোক কোনো দলিল পত্ৰ দেখুওৱা নাছিল। মোৰ ঘৰৰ পূব দিশে হৰেণৰ মাটি। এইটো সত্য নহয় যে মই প্ৰথম মাহত 1000 টকা দৰমহাত আৰু পাছত বিঘাই প্ৰতি 3 মোন ধান চুক্তিত খেতি কৰা কথা মিছা। দলিল কৰা সময়ত মই
So in the cross, nothing has been found out.
Even your lordship will look at PW1 also. The PW1 has categorically admitted that মাটিৰ দখল মোৰ লগত আছে. Your lordship will find.
But that I have seen.
Yes. So
No, but
there is nothing in regard to position.
PW1 has said one sentence, Gosorio Jomir, the suitland. Gosorio Jomir দখল দিয়া সময়ত মই যোৱা নাছিলো মোৰ কামলা জালুকদিৰে মোৰ হৈ জমিৰ দখল দিছে. What about this sentence, my lord?
It is in regard to the 3 other persons.
No, he says Gosorio.
No, the 2 other
Suitland.
persons. No.
Suitland.
No. It is
Plus-
in regard.
Plus PW6 has also said, my lord.
Your lordship will find মোৰ দখলত বৰ্তমানো আছে specific in PW1.
PW6
And
has
even
also
today is also there. It is in my possession, my lord. And in between, after this,
Who is PW6?
PW6, my lord,
says
just a minute. Chart number, sir.
Huh?
Just
Lokhiram Bora.
yes. And your lordship may also look into the deed writer, also Guluk Chandra Bora, who has said that the others are said.
PW6 at page 4 says, Mukule Kina Mati Kinit Mukul Hoteo Halboa Dekisu.
Your lordship may look at the evidence of deed writer also, DW3.
Deed writer.
Deed writer has also been examined,
Deed
who has said, my lord, Guluk Chandra Bora. We have specifically pleaded fraud and undue influence, and it has been proved in the trial court, and the first appellate court has also affirmed it. It is a question of fact which has been duly proved, my lord. Your lordship will see DW2 Guluk Chandra Bora. Your lordship got it, my lord? Your lordship got it, my lord?
PW2.
3.
Ah. Yes.
মই দলিল লিখৰ কাম 1981 চনৰ পৰা কৰি আহিছো। গত 15/5/99 তাৰিখে মই প্ৰ 1, 2 আৰু 3 দলিল 3খন মানে এক্সিবিট দলিল 3খন কামপুৰ সাব ৰেজিষ্ট্ৰাৰ অফিচত লিখিছিলো। সেইখন দান দলিল। দলিলৰ গ্ৰহীতা মুকুল হাজৰিকা কথা মতে লিখিছিলো। তেওঁ আমাৰ কাৰ্যালয় আহি মোক এই দান দলিল কেইখন লিখিবলৈ কৈছিল। আনজন গ্ৰহীতা ননী বৰুৱাক মই চিনি নাপাওঁ। 15/5/99 চনৰ আগতে মুকুলৰ পৰামৰ্শৰ মতে মই দলিলবোৰ লিখিছিলো। দলিল লিখাওঁতে দীননাথ বৰুৱা যোৱা নাছিল। দলিল লিখাৰ দুদিনৰ পাছত তাৰিখটো লিখা হয়। পঞ্জীয়ন কৰাৰ দিনা মুকুল হাজৰিকাই দলিল কেইখন লৈ
Mukul Hazarika?
Mukul Hazarika is the defendant number 2. Because he has been entrusted to take out the sale permission. He was the person who was entrusted to do the sale deed. What he has done, my lord, he has shown the 2 sale deed and got the 3 deed executed. পঞ্জীয়ন কৰাৰ দিন মুকুল হাজৰিকাই দলিল কেইখন লৈ এক্সিবিট 1725 আৰু এক্সিবিট প্ৰ 6-5 যথাক্ৰমে মোৰ চহী। দলিলৰ ক্ৰছ ফৰ প্লেণ্টিভ দলিলৰ ৰেজিষ্টাৰ কৰা দিনা 1:30 মান বজাত দিন বৰুৱা আৰু মুকুল হাজৰিকাক পাইছো। দলিলৰ খৰচ পাতি মুকুল হাজৰিকাই দিছিল। মুকুলক মই আগৰ পৰা চিনি পাওঁ। দিন বৰুৱা আগৰ পৰা চিনি পাওঁ। দলিল ৰেজিষ্টাৰ কৰা দিনাহে দেখিছো। দিন বৰুৱাই মোৰ সন্মুখতে চহী দিছিল। দিন বৰুৱাক দলিল কেইখন পঢ়ি শুনাবলৈ নাপালো। মিন্স দিন বৰুৱা মিন্স দ্য প্লেণ্টিভ। পঢ়ি শুনাবলৈ নাপালো। মুকুল হাজৰিকাই ইতিমধ্যে দলিল কেইখন লৈ যায়। দলিলত হাকিৰ চহীও আগদিনাই লিখা হৈছিল। দলিল লিখোতে বিক্ৰী পাৰ্মিশনৰ অৰ্ডাৰ মোক দিয়া নাছিল।
Dolil?
দলিল লিখোতে বিক্ৰী পাৰ্মিশনৰ অৰ্ডাৰ মোক দিয়া নাছিল। Means he was not shown the permission because the permission was for
The line previous there too?
দলিলত হাকিৰ চহীও আগদিনা লিখিছিল।
Then what is the cross-examination by the defendant?
Yes, sir. দলিল সম্পাদনকাৰী দীননাথ বৰুৱা। দলিলত মই দীননাথ বৰুৱা হৈ লিখিছো স্বজ্ঞানে সুস্থ শৰীৰে এই দলিল লিখা দিলো বুলি দীননাথ বৰুৱাই হৈ লিখিছো। মুকুলক মই আগৰ পৰা চিনি পাওঁ। পমিলাত মোৰ মাটি আছিল কিন্তু বিক্ৰী কৰা হ'ল। পমিলাত দীন বৰুৱা কেতিয়াও লগ পোৱা নাই। মিনছ এক্সিবিট 1, 2 আৰু 3 দলিল 3খন 15/5/99 তাৰিখে লিখা বুলি উল্লেখ আছে। এই দলিল কৰা 14/5/99 তাৰিখে লিখা বুলি উল্লেখ নাই। মোৰ দলিল লিখকৰ লাইচেন্স আছে। পাৰ্মিশ্যন নোহোৱাকৈ মাটি হস্তান্তৰ নহয় বুলি মই জানো। দেন এক্সিবিট 3খন মই দীননাথ বৰুৱাৰ কথা মতে দেন লিখিছো বুলি ক'লে। দেন খনো দীননাথ বৰুৱাৰ কথা মতে লিখিছো। মুকুলৰ একমৰ্ম অফিচ লিখিছো। দলিলৰ পৃষ্ঠাবোৰ দীননাথ বৰুৱাই কিনিছিল। মই আদালতত দীননাথ বৰুৱা আৰু মুকুল হাজৰিকাক দেখা নাই। লোকে কোৱা মতে লোকৰ দলিল লিখা কাম মই নকৰো আৰু আইন বিৰোধী কাম বুলি মই নাজানো। দলিল কেইখন কামপুৰ অফিচত ৰেজিষ্টাৰ হৈছিল। ননী বৰুৱা আৰু বেলেগ দলিল লিখিছিল যদিও নাজানো। মোক দিয়া সমনত কোনো পক্ষৰ সাক্ষী মাতিছে উল্লেখ নাই। এইটো সত্য নহয় যে মই সকলো দলিল দীন বৰুৱাৰ কথা মতে লিখিছো আৰু দলিল 15/5/99 তাৰিখে দলিল লিখা নাছিলো। এইটো সত্য। So nothing, my lord. Problem arises where, my lord? In the plain, my lord, we have specifically pleaded that this was by deceitful and fraud and undue influence. It was exact. 2 courts have given a concurrent finding on it. And this cannot be, as your lordship has held in the last order when your lordship has framed a new substantial question of law, that fraud or deceit or undue influence cannot be a substantial question of law. And so far 55, my lord, 54, I have
Where is
never
the
read.
trial court judgment?
Yes, madam. Trial court judgment, your lordship will find the type copy is at page 9. And in regard to possession, my lord, your lordship will find the observation at, my lord, your lordship can look at from
Number 3,
yes,
page 17.
yes. Whether give this number so and so were obtained fraudulently from a liable to be cancelled, my lord.
Number 6.
Fraud undue. That my প্রথম question. Page 24, your lordship can look into it, where because the evidence of DW3 and in the
Finding in respect of possession is in
your
paragraph
lordship,
22.
since your lordship is looking into, your lordship can see the stand of the defendants in their written statement also. On the basis of the deeds which they say, they obtain the namjari, mutation. Written statement of completion. Title should be 18. Hello. The lottery is rising. Hello. May kindly look page 117.
Yes, you're saying?
Your lordship is rising, I think. Yes, come. Your lordship is rising for 5 minutes. Kindly look at page 117 of the written statement. Normally, your lordship doesn't look it, but your lordship will just look it for a moment, my lord. What was the stand basically at page 117? Defendants came to know after filing of the suit that the plaintiff executed gift deeds in place of sale deed. In this regard, the defendants should file separate suit against the plenty for filing the counter claim. In this case, there was no counter claim, no suit for specific performance of the contract, my lord. Now, your lordship will see the deposition of DW2 Mukul Hazarika. I'll just read it, your lordship will tell us it. Dan Dolil বুলি জানাৰ পাছত মই পঞ্জীয়ক মহোদয় বা জিলা, this is in cross. দান দলিল বুলি জনাৰ পাছত মই পঞ্জীয়ক মহোদয় বা জিলা উপায়ুক্তৰ ওচৰত সেইখন ভুল বুলি প্ৰতিবাদ কৰা নাই বা কোনো গোচৰো কৰা নাই। মই দলিলৰ নকল লোৱাৰ পাছতহে নামজাৰি কৰাও। Means he knows that this is a gift deed, then even then he does and do the mutation. যিহেতু মই দান বিক্ৰী সম্পৰ্কে ভালকে নাজানো, গতিকে তেনেকৈ নামজাৰি কৰাও। মই কোনো দান বিচৰাও নাই আৰু গ্ৰহণো কৰা নাই। ননী বৰুৱা হৈ গোচৰৰ চোৱা চিতা কৰা কাম ময়ে কৰোঁ। ননী বৰুৱা মোৰ জেঠাই ছোৱালী। দীননাথ বৰুৱা মই ভাই নহয় আৰু ননী বৰুৱাও দীননাথ বৰুৱাৰ ভনীয়েক নহয়। Because that was stated in the gift deed. দলিল বৰা কৰাৰ দিনা বাকী কেইজনৰ দলিলবোৰ কি দলিল আছিল চোৱা নাই। এই দলিল কেইখন ননী বৰুৱাই আপত্তি কৰা নাছিল, দলিলৰ তলত কথা চিকা কৰা তিনিখনো এনেকুৱা কৰিলে জানাই। আৰু his admission is that এই তিনিওখন দলিল অবৈধ দলিল বুলি মই গণনা কৰোঁ। এইটো সত্য নহয় যে মই চক্ৰান্ত কৰে বিক্ৰী দলিলৰ পৰিৱৰ্তে দান দলিল। So basically, my lord, so far the facts are concerned, my lord, because from day one it was half that the other two deeds were also gifted, which is factually incorrect. Secondly, possession is still in with us till today, my lord. In between also during the pendency of this case, they tried to encroach upon it. We filed a police case and your lordship will not be concerned. So basically, as your lordship has pointed out that I'm obliged, my lord, that I got an opportunity to read this section 55(4)(b), because the plain context of this section says that it is a right given to the seller, and here it will be applicable only from the date on which possession has been delivered. And my respectful submission in this case, that possession was never delivered to defendant number 1 and 2. And there was no counter claim in regard to refund. And our specific case in the plaint was that these gift deeds are bad due to fraud and undue influence. Fraud means by obtaining the deeds deceitfully, my lord.
Okay, now let me put questions.
Yeah. And your lordship has.
Now let me put
Yes,
questions.
yes. Your lordship will not put me hard questions.
No.
Your
Very
lordship
simple.
knows my.
Very
If your lordship puts hard questions, then I have to take time to read it, because this is not a regular case for me, my lord.
Okay.
Only I'm where
Now
lordship.
you have read section 55(4)(b).
Yes,
55(4)(b) says
yes, my lord.
the seller is entitled.
Yes.
Seller means who? You.
Yes, yes, yes.
Where the ownership of a property has passed to the buyer before the payment of the whole of the purchase money,
Yes.
to a charge upon the property in the hands of the buyer. Any transfer without consideration or any transferee with notice of non-payment for the amount of the purchase money or any part thereof remaining unpaid,
Yes, my lord.
and for the interest on such amount or part from the date on which possession has been delivered, meaning thereby the interest will be calculated only from the date on which the possession is delivered. Otherwise, you are only entitled to the purchase money. This is what is 55(4)(b).
55(4)(b) says. But here it was never the pleaded case of the defendant. This was never the pleaded case of the defendant. Unless there is pleadings to the effect in the written statement, how do I answer it?
No, you don't require pleaded case out there. The case out here is simple. You enter into an agreement with the defendant for sale of this 12 bighas of land for a total consideration of 96,000.
Yes, sir.
You obtain the sale permission
Yes, ma'am.
and ask the defendant number 2 to prepare the deed of sale.
Yes, ma'am.
Thereupon, 41,000 was remaining to be paid.
Yes, ma'am.
So, the question is that on the date on which the execution was to be done, the defendant have stated, as per your plaint,
Yes, ma'am.
that look here, where 41,000 today is the bank holiday, I will pay you the next date.
Yes, ma'am.
In the meantime, you go to the Kanpur registry and sign that particular document.
Prior
Now-
to, prior to delivery,
What?
prior to delivery of the balance amount. Yeah.
No, you sign that document.
Yes, sir.
Saying that as it is a Saturday, we can't pay it to you. The payment will be made on the next day. So on Monday, when your son goes out there to get the 41,000, they say,
Of
look
not
here, where is
Sunday,
the
sir.
question of 41,000? You have executed a gift deed.
Yes,
So the payment of 41,000 is not there.
yes, madam.
Now the question is, when the intention of both the parties were very clear to the effect that it is actually a sale deed, as it be seen from the agreement for sale itself.
Yes,
Therefore, the question will be, isn't it your cause of action is only for the 41,000?
So far the plaintiff was concerned, our prayer was specific, that this gift deeds has to be cancelled.
You may ask for many reliefs. The question is, what is your actual cause of action? The cause of action is 41,000.
Plus this, deceit and, fraud and,
Fraud will come later on,
Yes,
I'm saying. What is the fraud? The fraud is, you have duly executed the document. The fraud happened on the next date when you came to learn that that 41,000 is being deprived from you only on the ground that, look here, it is a gift.
yes,
That is the fraud.
yes.
But the fraud is not on the execution by you.
Execution is again a fraud on the day because, the deed was executed by me,
Knowing it to
Thinking-
be a sale deed.
sell it. They
So
didn't
therefore,
give. So
therefore,
this-
your basic intention was to transfer him the property.
Yes, madam.
Now come to section 5 of the
Yes.
Transfer of Property Act.
Yes, madam. 5.
In the following sections, transfer of property means an act by which a living person conveys property in present or in future to one or more or other living persons or to himself and one or more living persons, and to transfer property is to perform such act.
Yes, madam.
So therefore, what you do, you execute a document knowing fully well that you are going to transfer it to him. Only cause of action out here that is you have not been given this 41,000, therefore you have a cause of action. That's it.
And plus, this transfer was done on the basis of the gift deed. We say that we will not go, transfer you the amount of the property because you have deceitfully and fraudulently executed the deed. And there is no claim, there's no-
Your case is not that. You have not, I would not transfer you the property. I would have transferred you the property if the name of the deed was a sale deed.
Yes.
That's it.
Now,
So
since
that
he
is
has-
actually because your intention of the parties have been all that it was the intention that should be a sale deed.
No, my lord,
Now they have not. What suit they were referring at page 117?
Yes.
Tell me, what is that suit?
yes, 117, WS.
What is that suit?
Just a minute.
What suit is he referring to?
The might suit.
No. He is saying that I will file a suit. What is that suit?
For filing the counterclaim.
What suit? What counterclaim is a suit? What
Yes.
suit is he referring to?
I don't know whether he has not elaborated. He said counterclaim means counterclaim in regard to, it may be refund of the money or
No,
it can be,
no.
for the specific performance of the
No,
contract.
he says, if you see the entire paragraph, it means that he wants to file a suit under section 26 for rectification of the name. That's it.
That was never done.
Which he has not done, that is a different thing.
Yes.
But the question is, all along, therefore, the cause of action was non-receipt of 41,000.
But in cross, he has said that no consequence.
What is the fraud? The fraud is what? That he has not paid you the 41,000. That is the fraud.
And second fraud is that he had deceitfully obtained my signature in the gift deed.
You
which-
went out there. All of it, on your own you went there. Are you saying that you don't know how to read? No.
He's an old man of 77 years.
You were 77 years as on that date.
Most probably, I have to look into fact. He's expired. His son was my age.
Expired, everybody will.
Well,
What is your age?
I'll just check.
1999?
71 in 99.
No, no, 71.
You'll look into the plain, my lord.
No,
Plain, there is no age.
deposition, my lord.
Deposition.
2001 it was recorded. At that time he was 71.
71. So he was 69 years old. 99, the suit was filed.
Yes,
So,
He has taken advantage of that old man, my lord.
old man to what effect? That deprive him of that 41,000. Nothing more than that. You had no other cause of action. One is to therefore read it. What is the cause of action at the end of the day? The fact that you have signed out that the document is not in dispute, the fact that you have obtained the sale permission is also not in dispute because that is your admitted case in your plain.
No, my lord, in so far to execute.
Kindly see your paragraph in the plain, forget about the evidence. Kindly see. Paragraph to page 84. Paragraph 3, the subpara.
Your lordship will look in the original plain condition. Okamia. Just a moment. I'll look into the original first. উপৰোক্ত ৰূপে বাদীৰ লগত, your lordship will read the original plain.
Yes.
উপৰোক্ত ৰূপে বাদীৰ লগত 1, 3, 5 আৰু 8 নম্বৰ বিবাদীগণৰ বাইনা বন্দোবস্ত হয় যদিও 2, 4, 6, 7 নম্বৰ বাদীগণে উক্ত 22 বিঘা 3 কঠা পুনৰ লেচা মাটি উক্ত বিবাদীগণৰ ইচ্ছা অনুযায়ী খৰিদ দলিল কৰা সময়তে তেওঁলোকৰ নামটো বিক্ৰী দলিল কৰিবলৈ বাদীক প্ৰস্তাৱ কৰাত বাদীয়ে বিবাদীগণৰ ইচ্ছা অনুযায়ী যিভাৱে আৱশ্যক তেনেদৰে বিক্ৰী দলিল কৰি দিবৰ বাবে সন্মত হয়। এই অনুযায়ী 1 আৰু 2 নম্বৰ বিবাদী একেলগে গোচৰীয় নিম্ন ক তফচিল বৰ্ণিত 12 বিঘা মাটি কিনিবলৈ সিদ্ধান্ত কৰে আৰু বাকী বিবাদগণে 10 বিঘা 3 কঠা পুনৰ লেচা মাটি কিনিবলৈ বিবাদীগণৰ ভিতৰতে বুজাবুজি কৰি সিদ্ধান্ত কৰি বাদীক জানিবলৈ দিয়ে। বিবাদীগণৰ ইচ্ছা অনুযায়ী 1, 2, 3, 4 আৰু 5 আৰু 7, 6, 7 নম্বৰ বিবাদীগণে গৰুবাদ মৌজা চিতলমাৰী কিচামৰ 138 নম্বৰ ম্যাদী পট্টাৰ 85 ও 84 ডাগৰ 6 বিঘা 4 কঠা 4 লেচা 139 নম্বৰ ম্যাদী পট্টাৰ 665 নম্বৰ ডাগৰ 2 বিঘা 1 কঠা 12 লেচা আৰু সোয়েঞ্চো ম্যাদী পট্টা সোয়েঞ্চো মাটি লেচা হস্তান্তৰ অনুমতি বিচাৰি গত ইংৰাজী 5/5/99 তাৰিখে জিলা উপায়ুক্তৰ ওচৰত আবেদন কৰে। তদুপৰি ও গৰুবাদ মৌজাৰ পমিলা জাননী কিচামতৰ 18 নম্বৰ ম্যাদী পট্টাৰ 461 নম্বৰ ডাগৰ 4 বিঘা 3 কঠা মাটি সোয়েঞ্চোৰ বাবে নগাঁও উপায়ুক্তৰ ওচৰত বিক্ৰী হস্তান্তৰ অনুমতি বিচাৰি গত ইংৰাজী 5/5/99 তাৰিখে আবেদন কৰে। নগাঁও উপায়ুক্তৰ ওচৰত ইংৰাজী 5/5/99 তাৰিখৰ কৰা আবেদনৰ মৰ্মে বাদী ও বিবাদীগণে গোচৰীয়া 4 পট্টাৰ মুঠ 22 বিঘা 3 কঠা পুনৰ লেচা মাটি বাদীৰ পৰা বিবাদীগণে বিক্ৰী হস্তান্তৰ বিচাৰে। বাদী ও বিবাদীগণে কৰা বিক্ৰী হস্তান্তৰ আবেদনৰ তদন্ত সংশ্লিষ্ট কৰ্তৃপক্ষৰ পৰা প্ৰতিবেদন লৈ নগাঁও জিলা উপায়ুক্ত মহোদয় ANR নম্বৰ সোয়েঞ্চো নম্বৰৰ অনুমতি পত্ৰযোগে গৰুবাদ মৌজা চিতলমাৰী কিচামতৰ ম্যাদী পট্টাৰ উপৰোক্ত উল্লেখিত ডাগৰ 18 বিঘা পুনৰ লেচা মাটি প্ৰতি বিঘাত 8,000 টকা মূল্য নিৰ্ধাৰণ কৰি বিক্ৰী অনুমতি পত্ৰ প্ৰদান কৰে। তদুপৰি আন এক অনুমতি পত্ৰ NR যোগে নগাঁও উপায়ুক্ত মহোদয় গৰুবাট মৌজাৰ পমিলা জানুৱাৰী কিসামতৰ 18 নম্বৰ ম্যাদী পট্টাৰ 464 নম্বৰৰ দাগৰ 4 বিঘা 3 কঠা মাটি সংশ্লিষ্ট কৰ্তৃপক্ষৰ প্ৰতিবেদন লৈ বিক্ৰী হস্তান্তৰ অনুমতি দিয়ে। বাদী বয়োবৃদ্ধ অসুস্থ লোক, this is the plaintiff, বাদী বয়োবৃদ্ধ অসুস্থ লোক হোৱাৰ হেতু চলা ফিৰা কৰাত অসুবিধা হোৱাৰ কাৰণে 1 আৰু 2 নম্বৰ বিবাদীগণৰ ওপৰত বিশ্বাস আৰু নিৰ্ভৰ কৰি অনুমতি আদি ল'বৰ বাবে বাদীয়ে তেওঁলোকক দায়িত্ব দিয়ে।
Or permission.
মানে
For
everything.
permission.
For permission. Yeah.
Etc. Then,
Then,
paragraph 4.
উপৰোক্ত উপবৃত্ত দফাত বৰ্ণনা কৰা অনুযায়ী মাটি বিক্ৰী হস্তান্তৰ অনুমতি পত্ৰৰ দ্বাৰা বাদীয়ে গৰুবাট মৌজাৰ চিতলমাৰী কিসামতৰ ম্যাদী পটাৰ 18 বিঘা পুনৰ লেচা আৰু মৌজাৰ পমিলা জাৰণী কিসামতৰ লেচা মাটি বিক্ৰী হস্তান্তৰ বাবে অনুমতি পায়। উক্ত অনুমতি পোৱাৰ পিছত বাদীয়ে 1 আৰু 2 নম্বৰ বিবাদীৰ জৰিয়তে আন বিবাদীগণক বিবাদীগণৰ সুবিধা ও ইচ্ছা অনুযায়ী 12 বিঘা 3 কঠা 15 লেচা মাটি বিক্ৰী হস্তান্তৰ কৰি দলিল ৰেজিষ্টাৰ কৰাই ল'বলৈ জনায়।
Hey, this is the line. So you by yourself say that as per your convenience, kindly make the deeds of sale so that I am going to transfer it.
Yes.
Subject to payment of 41,000 from the
Yep.
defendant number 1 and 2. Now therefore your cause of action is non-receipt of the 41,000.
Yes. Now your loss will see.
No more, not
yes.
necessary. Therefore, the question is, what was the simple case? So the simple case, the look here, this is it. Which the defendant also should have filed an application for seeking rectification. Even in the suit also, they could have filed
Yes, yes.
without the counterclaim. That ask for rectification and by make the payment. That was the matter would have been over. Now, instead of that, I don't want to go to the possession and give you interest at 18% from 41 from the date. That is a better option. The moment don't make that submission of 55-4B that they are not in possession.
No, because your lordship, I had to clarify the position because my friend was
Understood,
claiming that they
everything is
are in possession.
understood, but you are not going to get a possession if the interest if you are not handed over possession. You see the basic idea why from the date of handing over possession is being given. Because once you are still holding on the possession, so he need not make any payment as regards pay any interest in respect to the promise because you have not handed over the possession.
Yes.
But once the possession is being handed over, then you lose all your rights over that particular land, and as such, you are not in a position to get the benefit of it, and as such, you are entitled to interest if he has not paid within that time. That is the basis why the amendment was brought, and this very aspect was brought in that judgment of Justice Sagir Ahmed. So therefore, this was being brought in. So the question is, payment of an interest, and that is the matter which was simple has been made complicated.
And my lord, so far the other query which your lordship has put it the other day to my friend, that whether this now give this can be converted by.
I'm not converting it. I'm reading it. I'll read it. I'm not converting it. What is the transfer? It is a transfer which all intention they had. I have therefore asked him on the last reason to find out where in cases this type of matter have been done. So that Mr. Mozumdar has not been able to find out.
I can
So
show.
therefore I should not give him the relief.
Mala, as an officer of the court, Mala, I can assist your lordship so far that intention is concerned. I have also looked into 3 of the judgments of the Honorable Supreme Court where that intention is there, that you have to read the intention of the entire document. But
Therefore,
that is,
I
but
told him,
that is not
I
the,
told him to
but
look
that
into
is,
the judgment of Justice Pardiwal.
yes, yes.
Where he has duly taken into note as to what is the difference between a, means whether it is written out there. In fact, if you see, there is a beautiful judgment of 1994 Karnataka, wherein it was mentioned as to whether a power of attorney, whether you write it as an irrevocable or not, that is immaterial.
Well, that,
What is the intention of the parties? What can is read inside it? That is the question which is there. Here, the intention of the parties, as you be seen from the plaint, is very clear that you wanted the 41,000, which he deprived you, and therefore this is the state of affairs.
we are obliged to your lordship that on the last occasion, your lordship has referred to the judgment of 2025 of Justice Paredulwala. I had occasion to go through it because of your lordship's query. There, your lordship has said that even if it is written irrevocable, then ultimately you have to say. But I have also got contrary judgment which says otherwise. But since your lordship has now put a query, your lordship will give me some time to reflect on it and come more prepared so that I can be in a better position. Because I got out 3 judgment on the intention of the document or from the intention of the plaintiff, what can be deciphered. But I would like to go from line by line of the judgment because a
In fact,
little facts in.
there's a very interesting judgment. In fact, recently this has been followed by the Supreme Court. It is the first judgment is of 1957. You may find it out there. That is, I think, the judgment by it is not much. Here it says that when you are interpreting a document, you are also to see, it means it was a judgment following a 1957 judgment of, I think, 4 judges or something. There it says it's the paragraph number, clause number 3 and clause number 7. The clause number 7 goes against clause number 3. Then you are to interpret it in such a manner that clause number 3 remains. Because that is the, you have to, and if clause number 7 goes against clause number 3, then clause number 7 is not to be read.
Your lordship is probably referring to Bhagwati Prasad. Bhagwati Prasad judgment by Justice P.B. Gajendrakar.
57, na?
Not 57, it is 65 SCC online SC 111.
No,
AR 1966.
no.
Your lordship. Paragraph number. Paragraph number 9. Paragraph 9, 10, 12. Paragraph 10 is actually maybe your lordship is referring. 9 is also 11, but paragraph 10. Eleven is the second. 1965 SCC online SC 111.
Page
111.
In fact, what I am saying, see, you made a submission that about section 55 4B, there is nothing in the pleadings.
This is more a,
The answer is therefore there in paragraph number 10.
that's why
So the question, as I was saying to you, these are aspects which can be very well read from the pleadings. which all the parties knew, that as to whether it should have been a sale deed or
Give it.
a gift deed or whatever may be, whether it was actually a sale deed.
But
So therefore, the question is here is the interpretation of the deed. Now you had all along, your entire thing was that it should have been a sale deed. Because I have never come across any judgment wherein normally it doesn't say anything to that effect that, okay, this I have not signed this, that is what I know. But your intention is very clear that you look here, I wanted to sell it to him. He did not give me this 41,000 and on the ground that it is a gift deed. This is your cause of action.
But subject to correction, my lord. When two courts, the last, even the last appellate court on facts, when it has come to a concurrent finding that these gift deeds were executed by fraud, deceit, and undue influence, then will your lord, my lord, sitting in second appeal, will go into those facts? Because undue influence of
This is
fraud.
not a, Mr. Kumar, this is not a question of interfering with the facts. The finding of facts is there. That yes, it was a gift deed.
Yes,
Yes, it was a fact that he had executed the gift deed.
yes, ma'am.
And these people have also shown it to be a gift deed and it was done through them. So the fact remains as it is. I'm not touching on those facts.
Yes.
But the question is, what was the intention? Whether the learned courts below were justified in holding that the suit was actually a suit for cancellation, or is it that the court should have construed these to be a deed of sale?
No issues frame on that regard. No issues was framed in that regard.
Not necessary. Therefore,
But-
why it is not necessary is there in paragraph number 10.
Yes, that's why, madam, subsequently following this paragraph 10, there are two other judgments. I'll need some time to
No,
reflect
there
on.
are
I will assist you.
There are many
Yes.
other judgments also to that effect. The
Yes.
law is very clear. Whether you state in your pleadings or not, but if from the pleadings you can cull out
Yes.
that this is the intention of the parties, why they have come up. Then in that regard, and the parties knew what was the case. What was the case? For you, the case was, then look here, they said to me that they will execute a sale deed, but what they did, they executed a gift deed and did not give this 41,000 on the ground that gift deed. On the other hand, the other side says, then look here, we also thought that this to be a sale deed. Later on, we have come to know that it is a gift deed, and now we will file a suit for counterclaim for rectification or whatever may be. But the intention of the parties were all along there that it is actually a sale deed.
No, but so far the defendant is concerned, my lord, the evidence says that they had done it intentionally as gift deed. Evidence of the parties in this case says that the defendants have deliberately done this as a gift deed. They had never had the intention to do it as a sale deed. Their evidence says that they all along had the intention to execute it as a gift deed.
Paragraph page 117 says that he thought it to be a sale deed. The defendant number 2.
But evidence says otherwise, my lord.
Evidence also says that
Even
I
the deed
thought it
writer
to be
and
a
all
sale
evidence
deed, and
says-
when I took it, I got my thing done, my mutation done.
No, deed writer says that they got it written as gift deed only. Mukul Hazarika, who was looking into it. Mukul Hazarika never had the intention to execute it as a sale deed.
How many deeds were there?
5.
All these 5 deeds were challenged.
No, 3, only 3. Because so far the others were 2 were sale deed. That's why, and we have recovered the consideration, so we have transferred them the position. That's why the caretaker said the position was granted to the other 2 sale deed. That 10 biga is again some other land, not this 12.5 biga, my lord. 419, 420, 421. But if your lordship wants me to reflect on this paragraph number 10, I had just got it in the morning today. I was reading it.
No, it is
Oh.
okay. This law is settled.
Yes,
There's no quarrel with that proposition, though. But the parties knew it all well.
But Mukul Hazarika, my lord, at the time of getting the deed written by the deed writer, did it purposefully as gift deed already.
Therefore,
And he has
therefore
written it.
he became a hostile witness.
No,
He cross-examined.
and he has written that Dinonath Borua is my brother and for my sister is a because in a gift deed, your lordship, there normally in a gift also there can be a consideration. But here this
No, no,
consideration
there
is
is no
different.
consideration.
Yes.
They have written many things, but the
Yes.
question is, in fact, it is a transfer.
Actually, I'm not used to, but I've seen the plain written in SMS and is worded very precise and to the point. Madam. We don't get nowadays to read such plain in SMS, madam. And people who used to write such plain, madam, most of them had gone to jail during those land scam cases, madam. It's a dying art, madam. Someone has to pick it up, madam.
Because the question of law framed by this court is whether the learned courts below were justified in decreeing the suit in favor of the plaintiff when it is an admitted fact that the plaintiff had duly executed the deed specifically described in the Schedule 4, and the grievance of the plaintiff could have been taken care of by the provisions of Section 55 4B of the Transfer of Property Act. This is the question of law.
The other question your lordship has said, because when a court frames the question, substantial question, we don't interfere. Because in the earlier, first time when it was framed regarding that those are the questions of fact, so it cannot be the substantial question of law in the second appeal.
So what to do?
Your lordship will give me some time and my friend also to reflect. We'll be assisting your lordship, but I don't, madam. But my friend has been also gracious enough to say that it can't be convert.
Next time, both argue only on 20 minutes. I'm enough with this.
Yes, ma'am.
And here, all these provisos, Section 5, all these things have no relevance.
Yes. Your lordship may first suggested date as per your lordship's convenience, madam.
Why don't you compromise? Compromise?
My lord, the original plaintiff has expired, sons are there.
Compromise? You see, if you compromise, then you may get a much higher amount.
Your lordship can refer it to the mediation, madam.
Absolutely no.
The lordship will give us some time in between ourselves, we'll do it.
Compromise the matter. Then you will get some more money.
Let him hear the offer
But
from my friend.
in a case of this Nasia, the offer is to come from them.
No,
How-
offer has to come
How
from
much,
you.
no,
I'm not
how
like,
much do they want? How much do they demand for compromise?
no, he is purchasing my property, he should give me the offer.
I'll give you, I'll give
The
you 1
offer
rupee.
is already there. It is only the question that, you see, if I'll allow the appeal. In my opinion, the appeal has to be allowed. Now, the question is 41,000 is the amount and which if I put an interest of 18% also, taking it, I can put only a 12% interest. If I put it, then also it would not go much. So therefore, I'm saying with quarterly rest,
Like a bank.
then only things may improve. But they're taking into
Let them
account.
come up with an offer, man. So we'll ask our client to consider.
Now, obviously, you cannot get whatever amount that which you would get today. Come up with some reasonable thing if it
Yes,
can be done out. Then I think if you can get some good amount, it is good. Otherwise, at the end of the day, you have fought the litigation, take the litigation expenses also.
For me, my is pro bono, because the son is my friend. Son is my, he is.
Then you'll be in a better position.
Then it
I can,
be-
I'll
then
try,
it becomes better.
I'll express your.
Because otherwise, I'm finishing it off. Enough of this type of matter.
Will kindly suggest a
Let
date
me
as well.
let me be the first one to write this type of plan. Okay, we finish it off on 3rd of June. Is the matter on 3rd of June at the top of the list?
Just a minute, madam.
Tuesday.
Madam, 5th of June, madam. 3rd of June, I have to go to Imphal. My mother-in-law has suffered a heart stroke. So, for first, second, I'll be in Imphal. So I have to come and read at least 5th, madam, subject to your comment.
No, 10th of June.
10. Yes, yes.
On which day? At the top of the list.
Yes, sir.
Only 10 minutes, both sides, no more. I've already heard from my opinion. It is only that thing that if you can come up with some compromises, you get
We'll
more
talk,
money.
my lord. I'll
If
express
you
it to my friend
don't,
also.
nothing is going to happen. And Mr. Mozumdar also, you also try to convince your client that
From our side,
merely
we will
because of the
as your
fact
lordship-
that this court may allow your appeal doesn't mean that you are not going to give him good
Since
money.
it has fallen from your lordship, my lord, once an offer.
Because
comes,
your,
I'll make it.
otherwise your substantial question of laws which have been framed earlier were notoriously horrendous.
Yes.
So under such circumstances, those substantial question of law had no meaning.
Right.
So this court had taken the pains to make a substantial question of law.
Right.
So if, for you to have a case, now if you have a case, compromise and come up with some good amount.
And I want my learned friend to implore and make an offer. that-
Both sides, both sides.
No, no, first offer must come from
These are
them.
agricultural lands.
Yes. But now I am told that the value has gone above crores. In now more than 1 crore, present market price.
My land friend is already indicating what he's going to offer.
No, no, that's why it's all near the projects, when new projects are coming up in Nagaon.
If it is in crore, maybe he will say no.
If you don't come up with a reasonable amount, you won't get anything. Once I dismiss it, then you would allow it.
Item 2.
Yes, what are these IAs for?
Lordship, all are these relating to substitution petitions.
Then,
All are substitution respondent as well as the appellant died.
then,
Lordship, today.
what?
What happened, Your Lordship, in this case, my client has now engaged some other lawyer, that is Chauhan, because I was supposed to go for a checkup, but I could not go, so I am here today. So,
You are appearing?
she is there.
Okay, come here.
She.
Argue,
Lordship,
argue.
Lordship, we have newly engaged in this case.
So what?
Lordship. We are
This
are
matter
filing
was
our
fixed
wakalat number.
on 19/2/2025 after 3 months
Lordship, few
at
days
the
back.
top of the list.
Lordship, few days back we received the brief, Lordship. Few days back we received the brief, Lordship. Today,
So what?
Lordship, kindly, 2 weeks time may be granted to. go
Okay,
to-
1 lakh cost.
Lordship, my senior is in like in court number 21,
Ask
Lordship.
him to come. Else face the cost of 1 lakh. Whichever you want.
My senior is in late, Lordship.
Okay, 1 lakh. Ask him to come. We'll take up the matter.
I will assist, it is also on regarding.
You don't assist.
substitution.
If the file has been taken away, either you argue the matter, Miss Madam, you either argue the matter or ask somebody else. Come up with this that I'll partly coexist.
That is the.
And argue. How much delay
In all cases, different dates, Your Lordship.
is the delay
And one case is 518 days delay.
with the respondent? Who died?
Which
If
was-
lordship will, the first case, that is for respondent, now delay in filing petition. Second case is for substitution respondent number 3. And third petition is, they'll file another application for order 1 rule 10 application. After that, they think that the substitution petition should be taken, then again file, that is delay almost 1,826 days.
What is that?
It is appellant number 1
Appellant number 1 died.
died. Yeah, and they 1746. Delay of filing the substitution is 1,826 days.
Why? Why is the delay?
They are appellant.
Have you read it? Protection IA দিছে না?
Item number 6, no? Appellant number 1.
Section 5, 354 days.
10 number 6, serial number.
So respond number 5 had died. I think 14, 65, 66 and 64 are all for respond number 5. Madam,
Yes,
you
Your
need
Lordship.
not give me, you need not take the pain of arguing the matter. What you only take the pain of telling me which case is for which respondent.
Yes,
If you can do that also, that will be a great service to
No,
this court.
I'm agree, Your Lordship. Because 5 was not with me, so I could not arrange that. I'm trying.
So
We are
that also
assisting.
you can't say.
I'm assisting, Your Lordship.
Not, you have no assistance.
Respondent number 5 was Azimuddin.
Assistance is
He died on 23/7/2022.
necessary. Enough.
Respondent number 5, Azimuddin, died on 23/7/2022.
Not necessary. Who died again? Let us see.
IN number 1464 of 2024 was filed. Section 5 of the, under section 5, with delay of 354 days, Your Lordship. And IA 1466 was filed for setting aside abatement.
This is RSA number key. What is the RSA number?
23.
23 of 2009.
These are for miss case 3414, 3415 and 3416 is for respond number 5, isn't it?
Yes.
No, respond number 3.
I am for 2 and 7.
No, this is respond number 3.
Yeah, this is respond number 3.
And
1, 2,
1464 and the connected petitioner is respond number 5.
5.
Then 168. 68. 68. Respond number 1. 22-4 and 22-4 and 22-9. This is filed within time. 22-9, na? Respond number 1.
Respond number 1 is substitution delay of 518 days.
Huh?
Yes.
Respond number 1.
Yes. IA 1697.
When did he die?
4/10/2020. No?
4/10/2020.
And when was this application filed?
It was filed on
4/6/22.
4/6/2022.
4/6?
2022.
But the Supreme Court judgment is there, na?
So far the substitution concern, I am not on that one.
Delay is 5 days. Then 1467 and 1468 is respond number 1. And there is another connected one. Which one? And what is 1765? 765 is respond number 1. So these are all respond number 1. 531. Then who died? What are these? This case 23. This is, I think, this is 23. Issue notice by registered post. Order 1 will tend for addition of the legal heirs of appellant number 1. Appellant number 1, when did he die?
Number 1.
6.
I think 12/2010.
13/12/2010.
This was filed in 2012. So This was when the appellant and somebody by hand has put order 22, rule 2 and rule 3 also. You have done. Who is Amit Kabra, your junior? So this type of petitions are filed. Then 23, appellant died. Then miss case of 23, 2176. Again, appellant number 6 died.
Yes, Your Lordship. He died long against, already her legal heirs are on record, only two daughters were not on record. So petition was filed that they may be also aided as a appellant,
Why is it necessary?
because as
Means
per-
you got a substantial question of law admitted and therefore to delay the appeal. That must be the reason.
then why they are
That is the
dying?
reason.
Your Lordship, if it
Now
is
you
like-
don't have the file. Yes, Mr. Chauhan, come back. It is IS 1764. (1826) for appellant number 1, that one, that has been filed subsequently. Now you are appearing for whom?
2 and 7.
Now there will be a lot of substitution.
For substitution, so for the substitution concern, Lordship, with the appellant, Lordship, is old pending case, appellant maybe Lordship will be substituted. And the respondent is most of the, if they, even they were at this stage, they are, Lordship, they allow the disposition, then another delay will be because they have to send notice to them. So for my degree appellant, if the Lordship, appellant are admitted because it is a case of a concord party or a partition based on a document which both court says there is a no partition. Therefore, if the appellant is substituted,
Mr. Rua, don't worry. Let me substitute the appellant and hear the appeal.
yes,
And appeal I dismiss. Then not necessary.
that
Isn't
is what that even
If I substitute and pass an order against you or those persons,
Yes, sir,
then
that-
it would
that-
be
yes.
unfair. I can't pass the order against the
Yes,
person.
yes.
But I can very well pass an order in favor of that
Yes.
dead man also. So let me therefore substitute the appellant and hear Mr. Chauhan on the substantial question of law and dismiss it.
My lord, so for hearing on the substantial question, I am not prepared at all today, my lord. Because
Why did I have it on the top of the list?
my lord, Ukalatnama only come today with my lord. And I was busy, my lord, because of six partner matter today, my lord.
Now, Mr. Chauhan, didn't you see this matter has been put at top of the list?
Yes, my lord, sister told me.
So she will argue. So let her argue.
My lord, so far my lord, substitution is concerned, your lordship pass order, my lord, and my lord, if my lord kept your lordship partner, my lord, I will argue, my lord.
We don't require partner for that. Appellant number 1. Now let us see the plaint. How is it done? Where is the plaint, Mr. Borua? Plaint.
And 39 to 48.
Idris Ali. You are the plaintiff?
Yeah. I'm not the plaintiff. He's the plaintiff.
So there, in 2 courts, the suits have been dismissed.
Yes.
And what is the suit for?
for declaration partition
Plaintiff number one,
And
two,
induction.
and the defendant number so and so is the Iman in respect of Iman which was pursued by the plaintiff number two and 8 separate. Because 5. The scheduled land be measured initially through a commissioner appointed by the court. And what is the finding?
finding of the trial court is that they have failed to, the document of the partition is not, is a illegal one, and they are not, and moreover, the plaintiff number 1 and 2 have a not right over the land because it is not an ancestral land, it is purchased by one Sultan and Multan.
Sultan and Multan, have they,
Sultan, and
Sultan is defendant number 2.
the Sultan, the son of Sultans are the defendant number 1, 2, 3, and 4. And the
Multan,
son and daughter of the Multan is petition number plaintiff 3, 4, 5, 6, and 7.
so therefore, they don't also have a right of partition.
No, that is not a question of right of partition.
Ah.
Our case is that there is a suit land. Suit land is purchased by the one Sultan and Multan. And thereafter, after that, they are legal heirs, all legal heirs, they are in their respective share of land. On 2002, the properties got fired. And thereafter, after that, they are all constructed and some portion of sale by the defendant, some are the holding of petitioner. The plaintiff case is that during after the land was got fired, the defendant occupied the land more than his share, and some of the land has already been sold. And they want a decree that the partition which has been made by them on 1993, on basis of that, they sought a decree.
Now, who were representing the respondents here in the appeal?
Yeah, I am the appeal. I am representing the 2 and 7.
Suleiman Sheikh, who was representing these defendants earlier?
No.
Your Lordship, notices were served on the respondent, but they did not appear, only 2 and 7 appeared. As per report is there available, and order sheet also will say that the notices were served on all the respondents, but they did not appear. And you see the order passed on 6/12/21 and 10/2/2023 in RSA.
They are of no use. You are all relatives. Yes. By this present order, this court proposes to dispose of all the interlocutory applications. First, IAC 1764/2020 is an application filed under Section 5 of the Limitation Act seeking condonation of delay in filing the application seeking for setting aside the abatement. MC 2176/2012 and MC 2175/2012 are also applications filed under Order 22 Rule 3 and Order 22 Rule 9 for substitution of the appellant number 1 who expired during the pendency of the instant appeal. These applications under Order 22 Rule 3 and Order 22 Rule 9 hold on. Appellant number 1 no, it will have. And 3416 কোন কোড করলাম 34160 এখন করেছে মিস কেস নাম্বার 3416 where is that Watson? All these interlocutory applications. Miss case number 3414/2010 is an application filed seeking condonation of delay of 136 days in filing the application for setting aside the abatement this is for whom? Setting aside abatement for whom?
Matiur Rahman.
Of the respondent number 3 to the instant application, instant accompanying appeal. Miss case number 3415/2010 is an application filed for substitution of the legal heirs of the respondent number 3. Miss case number 3416 of the 2010 is an application filed for setting aside the abatement insofar as the respondent number 3 is concerned. Full stop. It is seen that from these applications, that those for the service of notice, steps were directed to be taken seen that service have been duly affected upon the respondent numbers, upon the said legal representatives, and none have opposed the substitution. Considering the above, the delay in filing the application seeking setting aside of the abatement, as well as the application seeking setting aside of the abatement, stands allowed. Accordingly, the respondent number, accordingly, respondent number 3 herein is substituted by with the names of the persons substituted by his legal representatives, the details of which have been given in paragraph number 3 of the instant application of the application filed under of the application being Miss case number 3415/2010, and they are arrayed to the accompanying appeal as respondent number 3.1, 3.2, 3.3, and 3.4. Okay, let me come back. You, during the lunchtime, you prepare, huh?
But I have
Prepare. We'll argue
case
on
number
this.
of pattern metal in code number 23, madam.
So what?
5, 6, 7, 8, 9.
Then, madam, you prepare.
2, 3, hello, check. Check 1, 2, 3. 1, 2, 3, hello. 1, 2, 3, hello. Paise sound. Check 1, 2, 3, hello. Hello, hello. Check
1, 2, 3. Hello.
Miss case number 2175 of 2012. Is an application filed for substitution of the appellant number 1 who had expired on 13/12/2010. By the applicants. Number 1A to 1E. This case number MC number 2176/2012 is an application filed for substitution for setting aside the abatement for substitution of the appellant number 6 who died on 23/4/2011. This case number is an application filed for addition of the remaining 2176/2012 is an application filed for substitution of for addition of the applicants in as much as the upon the death of the appellant number 6. Full stop. This application has been filed taking into account that the appellant numbers two, three, 4, and 5 are already there on record who represents the estate of the appellant number 6. But the daughters were not parties to the said suit, upon whom rights also devolve upon the death of the appellant number 6, who was the mother. It is also relevant to take note of that IAC 1764/2020 is an application filed seeking condonation of delay of 1826 days in filing the application for substitution of the legal heirs of the appellant number 1. Who expired on 13/12/2010. Why it is 1860?
The reason we have given a lordship that the legal heirs, those who were not aware about the filing of this pendency of the appeal
Not
before-
that, I'm not on that. You filed the application
on-
when?
Your
In
lordship,
2012,
yes, your lordship.
and he died in 2010.
Yes, your lordship.
Then why it is 1862 days?
Because I filed, at that time, we filed petition only under order 1 rule 2 for substitute, for impleading the legal heirs of applicant. And then the court asked us to file petition for the condonation of delay and abatement. So we filed it in 2020. So
This court taking into account that the appellant number 1 expired on 13/12/2010, and the application being Miss case number 2175/2012 was filed on 16/7/2012, is of the opinion that the delay that could be attributed is around 300, around a year. This court had heard the learned counsels appearing on behalf of the parties in these applications, and taking into account that the appeal is presently continuing, and the appellant number 1 was appellant continuing, comma. And the provisions of Order 22 is for the purpose of continuation of the suit. It is the opinion, it is therefore necessary that the appellant number 1 is substituted by his legal representatives by condoning the delay. Accordingly, IAC 1764/2020 is allowed by condoning the delay, and MC 122175/2012 is allowed by substituting the applicants as to the accompanying appeal as appellant number 1.1, 1.2, 1.3, 1.4, and 1.5. Likewise, the application being Miss case number MC number 2176/2012 being an application under Order 1 Rule 10, the applicants are arrayed as, are substituted against the appellant number 6 as to the, in the accompanying appeal as appellant number 6.1, 6.2, 6.3, and 6.4. MC number 2176/2012 is accordingly disposed. এখনো dispose of কৰি দিব দেই তাতে 1765 তাতে আগতে 1765 এইখন যে 2175 খন য'ত কৰিছো তাতে লিখি দিব 1765/2020, which is for setting aside the abatement of the appellant number 1 is allowed Now let this court take note of the applications being IA C number 16797 at oblique 2022 and IAC number 1698 oblique 2022. IAC 1697 oblique 2022 is an application for setting aside the abatement insofar as the respondent number 1 who expired on 4/10/2020 IAC number 1698 oblique 2020 22 is an application filed for substitution of the legal representatives of the respondent number 1 whose names have been duly mentioned in paragraph number 3. This court have duly taken note of that the application that the respondent number 1 expired on 4/10/2020 and the applications were filed on 4/6/2022. Taking into account the order of the Supreme Court in the case order dated 28/2/2022 passed in re cognizance. What is the name? Number? Repetition number 5 or something like that. Both of you don't know.
15.3 relaxation by Supreme Court regarding the condonation of delay during COVID period.
In view of the order being passed by the Supreme Court exempting the period of limitation, this court is of the opinion that the application so filed for substitution of the legal representatives of the respondent number 1 is within the period of limitation. And accordingly, both the application stands allowed, thereby impleading, thereby substituting the respondent number 1 by his legal representatives whose names have been duly mentioned in paragraph number 3 of the application paragraph number 3 in IAC number 1698 oblique 2022. Accordingly, the respondent number 1 is substituted by his legal representatives whose names are mentioned in paragraph number 3 of the application being IAC number 1698 oblique 2022 and arrayed in the accompanying appeal as respondent number 1.1, 1.2, 1.3, and 1.4. The three interlocutory applications being IAC number 1464 oblique 2024, 1465 oblique 2024, and 1466 oblique 2024 are applications seeking condonation of delay in setting aside the abatement insofar as the respondent number 5 who expired on 23/7/2022 semicolon for setting aside the said abatement and for substitution of the legal representatives of the respondent numbers, respondent number 5, whose names have been mentioned in paragraph number 2 of the application, being IAC number 1464/2024. Full stop. It is relevant to take note of that during the pendency of the instant appeal, the service upon the respondent number 5 could not be affected, and consequently, the appellant was not in know of the death of the respondent number 5. Taking into account the above, the delay of 392 days in filing the application for setting aside the abatement insofar as the respondent number 5 is concerned is condoned, the abatement insofar as the respondent number 5 is concerned is set aside, and the legal representatives of the respondent number 5, whose names have been duly mentioned in paragraph number 2 of the application filed for in IAC number 1464/2024, are substituted against the respondent number 5 and arrayed in the accompanying appeal as respondent number 5.1, 5.2, 5.3, and 5.4. The counsel appearing on behalf of the appellant is directed to file a fresh memo of parties within 3 days from today before the registry of this court, and the registry shall, on the basis of the said memo of parties, as well as the present order, make necessary changes in the cause title and update the same in the CIS. Then main appeal to the. In view of the order passed in the accompanying applications, issue notice by registered as well as usual upon the newly implemented, newly substituted respondents, being respondent numbers 1.1, 1.2, 1.3, 1.4, and 1.5. And 3.1, 3.2 hey gutikita je ase 3.3, and respondent number 5 na 5.1, 5.2, 5.3, 5.4, 5.5. The said steps be taken within 3 days from today. This court, further taking note of that the instant appeal is pending since 2009, fixes this appeal for hearing on 10th of June 2025. In the meantime, the appellants are directed to take steps upon the newly substituted respondents by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. It is observed that if no, is there any stay? No. It is observed if no steps is being taken as above mentioned, this court shall strike out the names of the newly substituted respondents.
May I pray, Your Lordship, Dasti will be difficult because some are living different, not in Assam. Some are in Bihar and different places. So Dasti will
Wherever
be,
you take it,
that will be, Your Lordship, register post we will take.
wherever you take it.
Your Lordship will pass Dasti, so And your lordship, it may be 1 week time because 3 days will not sufficient. So many respondents are there and applicants. So I will have require some more time to make ready all the steps.
Tomorrow is close given by the government, na?
Your
So you
lordship-
take those steps, don't sleep at home, do that work,
My
and then
request
day
before you
after,
lordship,
then
your lordship,
by
1 week-
Friday, why have I put it, Friday is the,
1 week time at least, your
no,
lordship.
nothing doing.
That will be,
Dusty, you have to do it by 2nd or whatever, 10th.
Dusty is not possible, your lordship, because
Not
here in
possible,
Assam, it
then
will
we
be done.
pass order.
But
Please
if those
pass.
in Bihar in different places,
Madam, if you don't take Dusty, I am putting it on Dusty for the purpose, and tomorrow when the matter comes up, your appeal is going to be dismissed.
that I know.
So
your-
therefore, the appeal is going to be dismissed. You take Dusty, don't take Dusty,
Your
that is
lordship already
immaterial.
has decided to dismiss my appeal. Either I take it or not take it, your lordship. Your lordship, my only.
But
humble
you see
request.
that it should be shown that you have given you an opportunity.
Your lordship, no, that I am much obliged, but your lordship, for
Yes,
outside
Madam, if you
Assam,
say something more, I'm
Only-
taking up the appeal for hearing.
so only one outside the Assam,
Lekho.
at least
Send
they
your
will be my
appeal
registered
conduct.
post.
Appeal conduct. Let me dispose it of. Argue on the appeal. Argue.
Your lordship, I start with the plaint.
No, no,
What is
no.
my?
Madam, it's we are in the
Because
second
yes,
appeal.
I have to made out my.
No,
case.
on
What
the
is-
second appeal.
I lost in both
Why
the
you
court.
are saying that these are substantial questions of law?
I have lost in both the court, your lordship.
You lost
So-
very well. Whether the judgment of the learned court below suffers from perversity on the account of non-consideration of material evidence, both oral and documentary, and misreading of some documentary evidence and non-application of mine. Why? Tell me. What is the material evidence which have not been taken
Because
into account?
material evidence was there were 2 deeds, partition deeds, which the court has not taken into account. Court is considering that no, that is because the defendant has denied that there was any such agreement or a partition deed between the parties. That has not been considered by the court.
So
That
these
is not
partition
considered.
deeds have not been considered.
Yes, your
Let
lordship.
us see why it has
Then
not been
whether the-
considered. Let us see the judgments, why it has not been
Uh,
considered.
Appellate court, your lordship?
Appellate courts.
Okay, yet, your lordship at page 9. Page 9, your lordship. May I read?
Yes.
This appeal having been preferred against the.
No, no, you don't read from top.
Your
Where is
lordship,
that?
I have to point out the end.
No, don't read from all these things. We come to the points for
Para 4, your
determination.
lordship, para 4.
Same for
Date
area
of the printing.
7, I have gone through from the materials on entirety area, most important area, the case of the plaintiffs. Agreement for the another deed of agreement was executed for both the parties on demand showing the respective. Material is the thing that transpired that the them. Which is the partition deed you are referring to?
Exhibit 2 and 3. Page 17, your lordship, in the judgment, para 12.
Now, did exhibit 2 and 3 have the signature of Multan Sheikh?
No,
What is wrong?
Abdul Aziz and Sultan Sheikh.
Multan Sheikh, you have, your right is for Multan Sheikh.
Sultan and Sultan, two brothers, they purchase and both, one is the son of, plaintiff with the son of Multan and defendants are the son of Sultan. So they will get half, both of them. So their partition, there, it was going on well, there was no problem. Only in 2002 when the fire gutted and house was burnt, and at that time, the defendant encroached little more land than their share. And that is my case, that what they have encroached more, that I should get back.
So therefore, your case is what has been encroached more, you have to get it.
Yeah.
How do you show that they have encroached more?
This is why, your lordship, we have made prayer also in the plain that the commission may be appointed, he will measure the land and he will in that way scrutinize the shares of the all the, but that was not done, and our suit was dismissed and the appeal was filed, appeal was also dismissed, and now I am before your lordship. Because unless the commission.
So what is the document which have not been taken into consideration?
So they have also denied that there was any such agreement. They are not, partition.
No, first of all, that document which is not signed by Multan Sheikh. Your entire basis is on that document.
Yes, your lordship.
Then, so you can't say which is the document, then why you are saying about perversity?
And the
The
second.
first section of law has gone.
And the substantial question, one more, your lordship, that.
Whether has the father failed to in his duty to reappreciate the evidence? My goodness. What that the decision of the learned district judge has no decree for, the no could be passed, because according to him, the civil court is not the proper form for passing a decree for partition, and the partition is a matter between the revenue authority and is not tenable. There you may have something. Yes. Whether the property belong to Sultan and Multan,
Yes,
then why there is no partition?
there is nothing in the trial court judgment. It is clear that they could not even show that what is their land. And the court is.
No, I'm not on that. I've seen that judgment now. The question is why you have stated that the Sultan, it is an admitted fact that the property belonged to Sultan and Multan. Then why the court cannot pass a decree for partition?
The court, that is because of the court did not partition, because of the fact that they could not even show their right about it, and they could not prove that document. That is clearly.
But isn't it an admitted fact that it belonged to Sultan and Multan?
But that is admitted fact. The land is, but the court, they could not say which land was belonged.
I'm not concerned. Let it be,
Yes.
whatever it may be. But how do you say that the court said that the partition cannot be there when it is an admitted case that it is a partition?
What the court says is finally the trial court. I refer the relief plain go para 21 of the plain, when plaintiff played for partition of the respective chair by appointing commission. The plaintiff is not entitled for the partition because instant suit in view of the provision, and the plaintiff are directed to file separate suit for partition in absence of person as well as right title interest of the plaintiff contained in page 7.
In fact, the issue has not been framed in that manner.
Yes,
Then the court should have looked into that.
the court, that is the finding of the trial court.
Understood. Finding of the trial court and first appellate court is there. But the question is, if Sultan and Multan are both owners at one point of time,
Yes.
they may not be exactly entitled to that particular area because they could not prove their settlement.
Yes. They
But
could not.
settlement.
Yes, yes.
But did you prove that there was a partition?
No.
So if you do not prove, can the person concerned who is a co-share owner seek for partition? That is the prayer number 1.
They, in the suit, particularly the suit they filed, they said they have a partition, they should, there is a partition of a 1993, and on basis of that.
Whatever may be, isn't it the
on
relief?
basis of that,
No, Mr. Counsel, kindly see the relief sought for in the plaintiff. Relief sought for in the plaintiff, kindly
Yes.
see
Page.
page 53. Page here, 47. That the plaintiff number 1, 2, 3, 4, 5, 6, 7, and 8 right title in respect to 1/4 share, that is 5.5 lectures each of the scheduled land, and in respect of 2.5 lectures and 4 lectures which were purchased by the plaintiff number 2, and 8 separates be confirmed, that the scheduled land be measured initially through a commissioner appointed by the court and plaintiff's possession be here, that on the basis of commissioner the final decree. So it is a suit for partition. So then the why on earth both the courts below came to finding that look here, they can very well go before the revenue authority. Isn't it the duty of the court when there is a dispute?
The plaintiff number 1 and plaintiff number 2, the court hold that they are not even they are not related to the land.
Okay, what about 3, 4, 5?
Yes, that the 4, 5 is Multan and Sultan is there, and they in the.
And therefore, all the appeal has been filed by not by the plaintiff 1 and 2.
Yes.
The appeal has been filed by Multan and Multan's the descendants.
Yes, Multan descendant file. They have not preferred an appeal because they know that they are not right of party.
So the substantial question of law number 3 arises involved. So this is a case where we should pass a preliminary decree.
Then if they could hold that is it is fact that the 154 is not come to the year of the DC. It is there. That part is that part I cannot know. It is a law. Multan and Sultan, the descendant of Multan and Sultan is entitled for the partition. That up to that extent.
So then why the court did not grant it? The court should have granted that. And in fact, they did not frame a issue in this regard.
Yes, they have not found an issue on that. And so because in the meantime, when and another aspect is they come to that time that the land, some land are already been sold by some person, and some.
I'm not concerned whether they sell it or not. It is for the court to look into it. The court did not look into it, that aspect. They went into the question as to whether they were.
Then in that you have to remand back to take. Again, you do the.
This is the one which you
only the.
Take your steps.
Yes, Lord.
You have an appeal, you have a good ground for appeal. The substantial number 3 is there. So you take it up, and on that day we are finishing it.
Yes, Lord.
This matter cannot remain any further. 2002 suits. My goodness. Okay, matter having been partly heard, matter would be that an attempt shall be made to dispose of the. Hey, the order to thaki, order to assume. You take the steps. We'll allow your appeal.
Item 17.
Yes. What is your explanation?
My lord, it has been fixed on 27/5/2025 for passing necessary order.
Huh?
For passing necessary order, I am told that presiding officer is not holding the office.
No, it's fixed on 27/5.
And in the meantime, have they given the evidence?
So the evidence is closed long time back, and after this order, my lord, I think there is an application for adjournment and all that. So therefore, it has not been proceeded at all.
They did not submit the evidence.
No, not yet.
Who has sought for adjournment?
Lord, either of the party possibly.
Twenty-seven-five.
27.
List this matter again on 14/5, today is 7, na? 14/5, 2025, on which date Mr. S. Dotto, the learned, on which date the counsel for the petitioner shall place before this court the order sheet pursuant to the impugned order.
Obliged.
Because even after this order being passed and they have not filed their evidence or they have brought on record that document, then we can very well interfere with.
Upgraded item 15.
ৰ'ব, 15 নহয়। আৰু এটা আছে নেকি? তিনটা বজাত আছিল। তিনটা বজা নাই না?
My lord, I have some problem, my lord. I have to go, my lord. I have a doctor's appointment with regard to my checkup on my wife, my lord. So, my lord,
Mr.
if
A.R.
not
Sikdar,
today, my
the
lord, then
learned
maybe another date, my lord.
The A.R. Sikdar, the learned counsel, submits that he has. The matter was simple, na? What was
Very
that?
simple, my lord.
Against preliminary decree, lordship.
What was that?
Preliminary
Against
degree was
final decree
not
already
challenged, they have challenged it after final
That
degree.
one. But the court made a mistake out there, saying that it is covered by the judgment. Covered by.
Section 97.
What is
lordship.
that?
Section
my lord.
97, lordship.
Section 30,
97,
97.
97.
But the fact that the court failed to take into account that the appeal, this was an appeal against the preliminary.
That is the.
What is the issue?
My lord, they have not filed the appeal against the preliminary decree.
My
That is the appeal which has been filed. Has the records come?
My learned friend has consent for upgradation, but he has problem at 3, lordship. He has consent for at 2, lordship. So, while we mentioned this matter for upgradation, my learned friend has consented. It was under impression that it will be taken at 2, lordship. But your lordship has given time at 3, so today he has some problem. Otherwise, lordship, it will take only half an hour, lordship. My condonation.
No,
was
only thing
allowed.
is required to be seen as to whether the appeal was filed against, whether the first appeal which was filed was against the preliminary decree. If it is against the preliminary decree, the court can't conclude under 97. Matter ends there. Isn't that the question
That
only?
is the only question. And one
Well,
more law point,
Any other
lordship.
day. Any other day.
Mr. A.R. Sikdar, the learned counsel submits that sometime may be granted as he has on account of personal difficulties. Taking into account the above, this the matter on 27th of May 2025.
13 May execution.
27th of May 2025. Yeah. At 2 p.m. Full stop. It is observed that till the next date, the judgment and decree assailed in the instant proceedings shall remain state.
Deeply
On which day, my lord?
27.
27 May.
Obliged, lordship.
Item 3, hearing under order 41, rule 11.
Judgment and decree dated so and so, passed in title appeal number shall remain. Yes, this is the third attempt
This is the third attempt, your lordship.
to get a substantial question of law formulated. Tell me.
Cost of repetition, I would like to say first, your lordship. There, according to your lordship, there should be two appeals, your lordship. One against the dismissal of the suit and the other one against the allowing of the counterclaim, your lordship. Here in this case, your lordship, I have actually given notice earlier. Double court fee has been paid, your lordship. One for the dismissal of the suit and one for the allowing of the counterclaim.
At page 10, your lordship.
Then,
It's so, it is a combined appeal, your lordship, for both dismissal as well as for.
how much was the suit value that?
Should value, it was value that to be 1 lakh, your lordship. And the other one is 1,50,000, 2,50,000, your lordship. Separately, court fee has been paid. At page 10, your lordship.
Yes, tell me.
Your lordship will find from the two judgments, your lordship, 9 witnesses from the plaintiff side, 9 witnesses from the defendant side, and your lordship will find that there is not a single witness, your lordship has been discussed by both the courts, except one certain Sharma, your lordship, who supports the case of the plaintiff, your lordship. Certain Sharma is a witness to the deed, your lordship, he has supported anyway, your lordship will find 9 from the side of the plaintiff, 9 from the side of the defendant, your lordship. 18 witnesses, your lordship. Not a single discussion so far the evidence is concerned, your lordship, by either of the courts, your lordship. And the findings are, your lordship, based on no evidence at all. There is complete non-compliance of order 41 rule 31, your lordship, and their findings, your lordship, are perverse, your lordship, and concurrently it has been done so, your lordship. No discussion, your lordship.
So what is your fraud?
So fraud, I have actually given it up, your lordship.
What is your
I've-
fraud?
I have given, because fraud is, your lordship, that he gave me assurance that he will be able to manage the bank manager to get the loan, your lordship, and for that, he shall have to give some signed papers, your lordship, on stamp papers. So, your lordship, on good faith and bona fide belief, as he is known to them, your lordship. So he signed some stamp papers, your lordship. And he converted those documents, your
Mention
lordship.
in which stamp papers, where is your statement made in your plea? Let's see.
Yes, your lordship, it is there, I am reading your, the relevant evidence. Your lordship. Because the plaintiff, there are 5 builders, your lordship. They are having only 1 kata 13 acres of land. There is no question of selling 1 kata of land, your lordship, keeping 13 acres. They are having their residential address, houses and structures.
Mr. Ali, I am not going to hear what is
Yeah, yeah,
not
yeah,
there in
yeah.
the records.
Correct,
Say
Your Lordship.
something which is there on the records. Come to paragraph 4, page 34 of your plain. That in the year 2007, the plaintiff number 5 is in need of heavy money, and the plaintiff number 5 intended to obtaining the loan from State Bank of India Patsala branch. Plaintiff number trying to get the loan from the State Bank of India since long, but failed. The plaintiff number 5 and the defendant number 1 are known to each other. Defendant is a greedy person, so the person in getting chance of a malafide is so and so.
Your lordship, page number, your lordship.
Page number 35, they had a good relation with so and so. So in order the remand had put his signature onto some non-judicial stamp paper and some white paper, and accordingly the plaintiff number put his signature up to some unwritten non-judicial paper and some white paper only on a good faith year. Now tell me, there are 2 deeds. 2 deeds. One is a deed by which the sale has happened, there is a gift made by the other plaintiffs in favor of the plaintiff number 5. And the second is the plaintiff number 5 signing the deed in favor of you.
Defendant
These
number
are the
one.
2 deeds.
Defendant number 1.
Event number 1. So now therefore, where is it mentioned anywhere in your pleadings as to how the fraud has been committed in respect to the gift deed?
Lordship, I am coming, your lordship. This your lordship, this number 3, your lordship.
In fact, the trial court duly reflects the evidence of, you say that the evidence of no evidence have been discussed. PW8's evidence have been discussed and stated that he has categorically mentioned to the effect that, look here, this particular person said that yes, he had made some sign, but he did not sign in any 500 or 1000 rupee papers.
So that is, lordship,
That is the material. So you have to show me which is the material, where is the perversity.
does that affect the merit, your lordship?
It affects the
I-
merit.
Your lordship, I am coming page 35 itself, your lordship.
Ah.
The defendant number 1 have a good relation with the branch manager. State Bank of India Pachala branch, and also told the main defendant number 1 have power to grant from the State Bank of India Pachala branch in the name of the plaintiff number 5 within very short period. So in this regard, the plaintiff number 5 with a very short period. So in this regard, the plaintiff number 5 necessary to put signature up to onto some non-judicial papers and some white papers, and accordingly the plaintiff 5 put his signatures up to some onto some unwritten and non-judicial stamp papers and some white papers only on good faith and for the purpose of obtaining the loan of the State Bank of India. The plaintiff number 5 demanded to the defendant number 1 on several occasions for getting the said loan, but the defendant number 1 failed to pay the loan to the plaintiff number 5, and thereafter the plaintiff number 5 repeatedly requested.
No, Mr. You have paid the court fee of rupees 2,700 in this appeal. Whereas the court fee paid for the counterclaim was rupees 3,144. So therefore, why you are saying that the court fee of both the appeals have been paid before the court?
The counter claim, your lordship, it is 2,50,000.
Whatever may be the
No,
court fee
on-
which was paid was the 3,144. So therefore, why you are making a statement before this court that you have paid the counterclaim, the court fee for both the appeals?
Lordship, I'm coming, your lordship, page 10, your lordship. Page 10. The appeal is valued at rupees 2,50,000. That means 1 lakh, so far the suit is concerned, and the other, your lordship, it is 1,50,000. So it is 2,50,000. Only for the purpose of jurisdiction and court fee, as it was valued in the suit for rupees 1 lakh and 1 lakh, again in the counterclaim rupees 1,50,000, 50,000, and separate at Balaram court fee of rupees 2371.60 and 3144 respectively is paid. 3144 means for counterclaim, your lordship. It is 2371, it is for the suit. Anyway, your lordship, juniors, they have drafted, your lordship, it is not.
Now here you have paid the court fee of rupees 2,737.
Lordship, total, your lordship, that is 3144 plus 150.
Huh?
237. And anyway, your lordship. the-
You have not paid the court fee. You have paid only for 2,737. This is the court fee paid.
Dear, your lordship.
Hmm.
Oh, I'm sorry, your lordship.
So therefore, the court fee has not been paid.
Oh, sorry, your lordship, that can be paid, your lordship. Still, I am ready to pay, your lordship. I'll tell the client, your lordship. My juniors, your lordship. Now they represented, your lordship, they paid the court fee for both the counts. Anyway, your lordship. Now, your lordship,
No, I'm not going to hear.
now,
Yeah.
now your lordship will find. So for the fraud is concerned, your lordship, that took signatures on papers, whatever may be the papers, giving assurance that they will arrange rent from the bank, and that was not done when I requested him that he give me the papers which I have
Did
signed.
the defendant plaintiff number 1
This
to
is-
4 adduce any evidence?
Yes, they have evidence.
What do they say? That that is not the signature in the gift deed?
No, so for signatures are concerned, your lordship. According to them, your lordship, these signatures were actually opted for some other reasons.
Not nowhere mentioned.
I just forget to give deed, your lordship. Supposing sale deed, your lordship, I am coming, your lordship. From gift deed, I got 1 kata of land from my brothers. So I have sold 1 kata of land to given number 1. So that sale deed, your lordship, is it not necessary to prove, your lordship, regarding execution? Regarding, your lordship, that I have executed with the intention, your lordship, that it is a sale deed, that it was present, executed in presence of such and such, that I presented the sale deed before the sub-registrar, your lordship, that I have received some money, your lordship. Mere, your lordship, saying that the document has been marked, your lordship, without the same being proved.
No, it has
So
been
it is
proved.
the execution
That is a
must be
finding a
proved.
fact.
So Supreme Court says, your lordship, repeatedly, the execution must be proved, and the intention of execution, that also must be proved. Mere marking and mere saying that this is the sale date, your lordship, may I read the paragraphs, your the relevant paragraphs, your lordship? So I will, at the cost of the repetition, your lordship, our own decisions are there. Your lordship, I am furnishing to your lordship.
Not necessary.
I'm placing the decisions, your lordship, our decision. So sale date must be proved, your lordship, that this has been executed by me.
Both the courts have come
Mere-
to opinion
mere
that it has been proved.
Both the courts perversely, they have actually concurrently.
You cannot say merely perversely unless you say so.
Your lordship, there are 9, your lordship, I have relied upon. This is our decision of the year.
Original sale deed, original
yeah.
gift deed, all have been proved before the court.
So there is no discussion, your lordship, as regards the execution of the sale deed. There is no discussion at all that these are the persons, they were in presence and these are the signatures they have actually proved. Unless the signatures are proved, section 67, your lordship will find, that is no proof, your lordship. So that must be complied with, either by the author, by the witnesses, or by the expert. These are the three persons. And those are not complied with. Para 9, your lordship will go through. একটু করতে হবে। একটু।
You have not raised that issue in as a ground of objection in your appeal.
In the appeal, your lordship.
In the
This is
first
question
appeal.
of law, your lordship.
In
This
the
is
first appeal, you ought to have raised that.
Your lordship.
You don't raise anything, you come up in the second appeal, that cannot happen.
Your lordship, this is the second appeal.
Okay,
and
okay,
it is-
enough.
It is.
I have given you enough time. Now this is
No,
a
no,
case
your-
for
I
dismissal.
did not take enough time, your
I
lordship.
have given enough
I-
time.
I am on
Mr.
law, your
S. Ali.
lordship.
No,
Whether
enough.
leg-
I don't find any good ground.
Question is, your lordship, whether law is.
Let
to be
me
pleaded.
dictate.
Law
Enough.
should not be
No
pleaded, your
case, no case.
lordship. At least, your lordship, one sentence I am reading, your lordship. Mere registration of a document is not by itself sufficient to prove its execution. Again, the mere proof of a admission of execution before the register does not satisfy the requirements of section 67 of the Evidence Act.
I'll-
Section 67, your lordship. It is a
I'll take care of
ques-
it.
Question of law, your
Take it
lordship.
as a ground.
Lordship.
Let me dispose.
Lordship, let me read one more reason, your lordship. Just your lordship to satisfy your lordship.
1 lakh,
It will be dismissed, no doubt, your lordship.
1
So
lakh, 2 lakh,
I may be satisfied, your lordship, that I have argued the case on behalf of my client.
3 lakhs.
Now your lordship will find that is. That is 68, I am relying, your lordship. I am relying, your lordship, 2022 7 SCC, phase 1. $68. Right. May I read it, your lordship?
Yes.
In so and so, a division bench of the Bombay High Court in such and such, yes, section 68 of the Evidence Act held so and so, in Sargas Evidence Act, page 639, the meaning of the proof of the word execution has been set out. It says, executed means completed. Execution is the last act or series of acts which completes each execution, consisting in signing a document written and read over and understood, and does not consist of merely a signature and merely consists of merely signing a document, name upon a blank sheet or paper. To be executed, a document must be in existence. Where there is no document in existence, there can be no execution. It seems to us plain that a person cannot be said to execute a document where he does not do so with the intention of making it. This may appear to be simple, but it is clearly, in our opinion, full meaning of the meaning and import. The word execution, in a sense, means the making of a document, and a person can be said to have made or authorized a document, authored the document, where with the intention and knowledge of bringing into existence a particular kind of document, he prepares or gets prepared such a document and signs it in token of his having accepted the document with a desire to bring it into existence. Mere signing of a document without intention of bringing that document into existence, meaning thereby giving effect to it, would not properly speaking attract the expression execution. Therefore, Your Lordship, I am just relaying the other 73, Your Lordship. 73, the execution of a document does not stand admitted merely because a person admits to having signed the document. Such an interpretation accounts for circumstances where an individual signs a blank paper and it is later on converted into a different document, or when an individual is made to sign a document without fully understanding its contents. Adopting a contrary interpretation would unfairly put the burden upon the person denying the execution to challenge this registration before a civil court or a writ, since registration will have to be allowed once the signature has been admitted. Your Lordship, the other paragraph, Your Lordship, I forgot, Your Lordship, that is 63, Your Lordship, important, Your Lordship. A division bench of the Madras High Court, while considering the provisions of so and so, the admission required therefore is admission of the execution of the document. It is not enough for the person who is ostensibly executant to admit his signature on a paper on which it may be the document is ultimately engrossed. The identity of the papers on which the signature occurs is not sufficient. If a man says that he signed a blank paper on the representation that it was required for presenting a petition, as in the present case, or if a man signs a completed document on the representation that his signature or thumb impression is required as an attesting witness, that admission of the signature or thumb impression in those circumstances cannot be construed to be an admission of the execution of the document. Far from it being an admission, it is clear an unambiguous denial of the execution of the document. He must admit, in order to attract the provisions of section 35(1), that he signed the document. The admission of execution therefore must amount to an admission that the person admitted entered into an obligation under the instrument. In other words, that he had executed the document, signed it as a sale deed, mortgage deed, or a lease deed, as the case may be. Here in this case, all these things are absent, Your Lordship, lacking, Your Lordship. And first thing, Your Lordship, first and foremost thing, Your Lordship, a document is to be proved, Your Lordship. If it is a document sale deed like mortgage deed or that, Your Lordship, it is 67. If it is a gift deed, Your Lordship, it is 68 of the Evidence Act. So these two provisions, they are legal provisions, and these two provisions must be complied with, Your Lordship. Now, suppose if I am forgetting, Your Lordship, this gift deed. So for sale deed is concerned by which he is having title according to him. So that document, Your Lordship, to get title, Your Lordship, just mere saying that this is saying this.
How do you bring in 67?
67, Your Lordship, that is proof of signature, Your Lordship.
Why?
Proof of signature is necessary because I have said, Your Lordship, that the signature, which according to them, Your Lordship, put by me, it was actually taken for, not for sale deed. It was taken for other purposes, and he has converted the document, Your Lordship, to suit his interest. And that is fraud, Your Lordship, already I have submitted, Your Lordship, and that signature, Your Lordship, it cannot be said that it is a signature only for the purpose of execution of this sale. There is no evidence, Your Lordship, that I presented the document before the sub-register. They have not proved it, Your Lordship. that document is there, exhibit one, your lordship, original they have produced, yours I am having. In that document, your lordship will find that there is no whisper that I have delivered possession of the land measuring 1 kata, your lordship, to the defendant number 1. Further, your lordship will find his claim is your lordship declaration of right, title and interest in respect of 2 kata, 10 and 1/3 lessons of land. Whereas my case is, your lordship, it is only 1 kata. He has actually again claimed land, your lordship, from other persons. Those persons are not party in the suit, either as defendant or otherwise, your lordship. As against that, how there can be a lordship partition? If you have purchased, your lordship, definitely you have taken possession. Now, your lordship, that document is there with me in the original, your lordship. And I am reading, your lordship, that document. কচ্ছ জমি বিক্রি হস্তান্তর কর খট্ট প্রথম মিটারে কার্যন যে আজি মোর নগদ টকাৰ প্ৰয়োজন হোৱাত মোৰ নিজ নামৰ স্বত্ব দখলৰ নিম্ন তফচিল বৰ্ণিত মাটি 1 কঠা মুঠ 2,40,000 টকাত উপৰোক্ত বৰাবৰৰ ঠাইত বিক্ৰী কৰি নিজ স্বত্ব বৰাবৰে উল্লেখিত মাটি এই বিক্ৰী দলিলযোগে নিজ নামে নামজাৰি কৰি লৈ চিৰকাল পুত্ৰ পুত্ৰাদি ক্ৰমে ভোগ দখল
The judgment and decree dated 9/8/2024 passed by the learned court of the civil judge, senior division Bozali, Patsala, whereby the appeal, being title appeal number 02/2023, was dismissed, thereby affirming the judgment and decree dated 28/2015 passed by the learned Munsip Bozali Patsala in title suit number 14/2008. First, the instant second appeal is admitted by formulating the following substantial question of law. First, whether the learned courts below were justified in dismissing the suit without coming to a finding as to whether the gift, the alleged gift by the deed number 496/07 dated. What is the date of the gift?
Gifted, your lordship, it is, coming, your lordship. It is dated 11/6/2007, your lordship.
11/6/2007. Have been, whether there was a gift, whether the learned courts below were justified in arriving on the basis of the evidence on record that there was a valid gift in terms with valid gift by the registered deed of gift dated so and so. Number to question was 496/07 dated so and so in terms with section 122 of the Transfer Property Act. Next, whether the learned courts below were justified in dismissing the suit and decreeing the counterclaim without whether the learned first appellate court were justified in dismissing the appeal without any discussion on the evidence on record. Full stop. Call for the record, steps be taken upon the respondents by way of registered as well as usual. Full stop. This court further takes note of that the counsel appearing on behalf of the appellants shall approach the registry within 3 days from today, and the registry shall intimate as to whether there is any additional court fee required to be paid. Full stop. Upon such intimation, if there is any additional court fee, the same be paid within 7 days therefrom. I cannot bear issue notice making it returnable on 16th of June. Be taken by way of registered as well as usual.
Item 4 for orders.
What are these? So many eyes.
In fact, there is an appeal, my lord. Appeal against an order passed by the learned trial court.
On IAM alert is for recalling of all of that order passed in 2014.
Yes. CRP খন আছে নি? This IA is in the CRP.
I is in the
Yes.
CRP, disposed of CRP. There are
One, the CRP which was filed by them. There were two CRPs, my lord. We had also filed the
There are two CRPs.
two CRPs. my lord.
What
I
is
don't
the
think
other
they have
one?
made an application, my lord, in that. So, my lord, I'll make my submission when, my lord, so I'm sure, my lord, will recall, my lord, the facts, of this matter.
in fact, the appeal, IA has been filed because of there is an appeal passed. Appeal is, whether there's this FAO 12 of 2024 is an appeal under Order 43 Rule 1R.
See, in paragraph number 20 of the judgment in civil revision,
Yes.
the first portions appears to be okay. Of the judgment in the CRP, where he is asking for recalling. Paragraph 20,
My lord, one, my lord, the original order, my lord, is looking at, my lord,
in the CRP,
130.
civil revision 47.
My lord, original, my lord, may I just take, just 2 minutes, not more.
No problem.
My lord, the plaintiff, my lord, had held shares, my lord, the original plaintiff, 861,198,918 shares in a company. He had purchased it entirely, and my lord, it was in his name. For operational convenience, my lord, he transferred it in the name of himself and his daughter. Then, my lord, he wanted to transfer the shares subsequently to, my lord, a trust, the family trust, where, my lord, everyone else, my lord, was a beneficiary. The
daughter refused. So he filed a suit against the daughter, asking for a declaration with regard to that the shares are entirely mine. Now, Malad knows in, at least Malad our part of Malad in India, Malad, there's no theory of advancement. Like Malad a nominee, if you put a nominee, doesn't mean the property belongs to you. Like if you put someone else in the, with you, along with you as a co-shareholder or a co-person, Malad, who was a second holder, you don't become Malad owner. So that was really the basis of the suit. Malad, while the suit was pending, Malad, the father passed away. Father left a will by which Malad, the shares were given to the family trust. The will probate application has been filed in Calcutta. Malad, all the heirs are consented except Malad, for the daughter. She's Malad, opposing Malad, the grant of probate. It is our case Malad, that she's delaying the probate. It's their case that no, we are not. When we Malad, applied for substitution, Malad, the court held that, sorry, since you're claiming a right through the will to the shares, we can't substitute you till probate is obtained, and kept the suit in abeyance. In the suit, Malad, there was originally Malad, also an order passed Malad, with regard to status quo, with regard to the shares. Quite naturally, Malad, there's a dispute with regard to who's going to Malad, have the shares finally. So that order Malad, will continue. And this is Malad, in the year 2013. That was the first order Malad, which was passed. Then the probate, the substitution application Malad, got the suit was kept in abeyance till, and the substitution application till Malad, we could obtain probate and Malad, come back and move this. Malad, we both filed civil revision Malad, from that. Both. I objecting Malad, to the order, they also Malad, objected to the order. That resulted in the order of Malad, 13th November 2014, which held on the basis of Malad, two judgments of the Honorable Supreme Court, which are of higher strength, to say that yes, the judgment is right. Malad, that judgment Malad, will find Malad, one is Malad Leelaram Malad Pandey, and Malad, the other one is Malad Hemnolini Judah. So held that no, sorry, unless you get probate, you cannot really be suspended and suit is kept in abeyance. This is Malad, the situation which continued. Thereafter, Malad, other proceedings were filed. They were all Malad, dismissed Malad, on the basis that Malad, the suit was kept in abeyance. Then Malad, they filed another application in about 2022, where Malad, 2020, where again they went and said, you dismiss the suit because there has been no substitution. And suit has abated. Malad, that application Malad, was to be taken up. There was a show cause notice issued. So Malad, again they came up in civil revision from that. The civil revision got dismissed, saying that you can't go on doing this forever. Now the suit is kept in abeyance. Suit is kept in abeyance. Still the probate is obtained. That's Malad, an order of Malad, this Honorable Court. Then Malad, in 2021, I'll show that Malad. Then Malad, they went up Malad, to the Honorable Supreme Court. Supreme Court also dismissed the special leave petition, saying that the suit is really not saying anything, but Malad, the whole contention was because the suit is kept in abeyance, nothing can be done. So order Malad, continues. Now on the same ground, they made another application, saying that now again the suit is kept in abeyance, either you vacate or you hear. Now that also Malad, again the trial court Malad, did not do refuse. That is Malad, the appeal Malad, which they filed Malad, the first appeal. That's the first appeal Malad, FA 12 Malad, which we are opposing. Then Malad, while it was pending, Malad, perhaps Malad, when Malad, it fell from court that what is happening to the other suit, now they made an application for recalling of the order of 2014. And so far as the shares are concerned, Malad, the Calcutta High Court already passed an order saying Malad, the dividend is going to be Malad, deposited Malad, in a separate account. So that's where we stand. So Malad, our stand, so far as the appeal is concerned, quite naturally Malad, nothing can be done in the appeal because the suit is kept in abeyance. And in any event, the injunction has to continue because shares are in dispute. And so far as this is concerned, we are in a bit of a Malad, situation where Malad, we really can't make submission because we wanted substitution. But unfortunately, Malad, the order records that relying on a judgment which was of superior strength of the Honorable Supreme Court, substitution was not allowed. And from 2014, both parties Malad, have accepted the situation, and that's Malad, where we stand. And we have annexed orders Malad, to show in the probate application Malad, in fact, that stopped Malad, appearing also now. The probate application Malad, is pending. They have made several applications there, take out this property, take out that property from the affidavit of assets. Malad, and Malad, that is Malad, what the situation is, where we stand.
Let us see those judgments.
Yes, ma'am. my lord, there, my lord, will find my lord, at 136, my lord, of my lord, if my lord has the IA 2553, there, my lord, the Hemnolini Judah, my lord, has seen, my lord, in paragraph 14.
Page 1.
My lord, 136, it's part of the judgment. 130, my lord, it starts. The civil revision order, my lord, of 2014.
Yes.
My lord, will recall, my lord, Binapani Kaur, my lord, we have used, my lord, but Binapani, my lord, really doesn't decide anything. That's what Binapani said, you can substitute, you proceed till you get the decree. But these other judgments seem to suggest, which I was also a little, my lord, taken aback, my lord, when I again, my lord, read and reread, my lord, the judgments. To perhaps it's saying, my lord, that you can't even, my lord, substitute. And the learned judge, my lord, has gone on the basis that because these are higher strength judgments, they're all both, my lord, the three judges bench, my lord, the copy of Hemnolin and Narayan Das Leelaram. I'm sorry, my lord. In Hemnolini, my lord, will look at paragraph 7 and the other one, my lord, paragraph 2.
Is this relevant, the judgment of Justice Gazette, Wanshu?
My lord, paragraph 7, my lord, has seen?
Yeah.
My lord, that's where, my lord, I think my lord, the learned judge is relied upon.
Understood, but you see, if I'm not
Well,
wrong.
My lord, this
The
is, my lord,
fact-
what has been held in 2014. Lord,
No, it's okay. But the judgment of Justice Wanshu is on the premises that unless 213 says that no person can gather any right over over any property bequeathed by way of an will unless it is probated. This is simple.
No, my lord, the section says no right can be established in a court of law without probate being granted. That's not probate or
is-
letters of admission. That's
That
what
is
section
what has been
213
stated.
of the
Now, what
succession.
has happened here? The daughter or whoever it is, she, without obtaining the will, without probating the will of her mother,
This is, my lord, the
yes, without
here,
obtaining
yes,
the
this is
a
better. My
will-
lord is talking about one, this is
Yes.
one, yes, yes.
without obtaining the probate of her mother, bequeathed the property to the daughter, and the daughter obtained the will probate in respect to the mother's bequest. Therefore, the court says that unless and until Mrs. Mittal had obtained the probate in respect to the property given by her mother, means the grandfather of the appellant herein, if it was granted by, without obtaining that, she could not have bequeathed the property to her daughter.
In fact, here, my lord would have seen, my lord, the daughter was not claiming any right under the will at all in this.
No, I'm not saying here, I'm not on
No,
this.
in one shoe. This is one shoe judge. I'm talking about this one, my lord, the Hemnolini. There, my lord, she claimed in the end that very well, give me half. In that context, my lord, the Supreme Court held that you can't establish a right because the suit was originally dismissed, then, my lord, it was decreed, my lord, by the High Court. Then, in that context, the Supreme Court held that you cannot establish a right in view of Section 213 to any property without obtaining a probate or will. My lord, we are at this stage, my lord. Question really would be, my lord, whether, my lord, 2014, my lord, we can go back and unravel. Because in view of 2014, a lot of other things have happened. The next civil division, my lord, has been dismissed. The Honorable Supreme Court has, my lord, also looked at it and, my lord, dismissed, my lord, the special leave petition. So it is really that situation. Because that's how, my lord, I see it. My lord, subject to, of course, my lord, what, my lord, the false, my lord, from court. Because relying on this judgment and, my lord, the other judgments, Narayan Das Leela, which is only, my lord, paragraph 2, Justice Sujata Manohar's judgment. My lord, will find, my lord, where and they are both, my lord, of a higher strength, my lord, in the sense, my lord, there were at that time, my lord, 3 judges sitting, my lord, in the bench.
How does this have any application?
My lord, only paragraph 2.
Yes.
There, my lord, will find, my lord, in view of Section 213 of the Indian, at the middle, my lord, about
No,
placidum D.
understood. Paragraph number 2,
Yes, that's the only paragraph.
here it says, it is however an accepted position that the legal representatives of the original appellant are already on record.
That
We
is why
therefore do
substitution
not
was
see
not.
any difficulty in transposing the
That's right.
respondent number 9,
Correct.
who was the executor, one of the legal representatives of the deceased appellant, meaning thereby this court has also, the Supreme Court had also substituted him.
But not by virtue of the will. the Supreme Court, my lord, will find not by virtue of the will. They say he's
Obviously.
one of the legal heirs, therefore we are really transposing him.
No, he was not a legal heir.
Yes, my lord, he was one of the legal heirs.
To me,
Lord, can you see? Therefore, we do not see any difficulty in transposing response number one of the legal representative of the deceased appellant as the appellant.
no, we do not find in the transposing of one of the legal representative of the deceased appellant as the appellant.
My lord,
Only see, the respondent
gentleman, my lord, had
filed an application.
two
for
wives,
being
my lord, and my lord,
substituted.
several, my lord, sons, and my lord, so they were all on record. So the right under the will, my lord, was not accepted, but my lord, because he was otherwise, my lord, no one would have pursued it.
But how does the court take note of what is the meaning of legal representatives? That has not been discussed in
That's
any
not
of the.
been. My lord, legal representative, my lord, as we, my lord, know either, my lord, he is an heir, or, my lord, he is, my lord, by way of the executor of the will also, my lord, is a legal representative.
But that has not been duly taken note of by either of the judgments.
My lord, because here, my lord, the daughter is the other side, in our case. So I am the only legal representative, my lord, who's going to pursue. Because under the will, my lord, it goes to the trust. The shares go to the trust. This was the situation, my lord, in 2014 order was passed.
No.
No.
The right of the trust is to be dependent on the 213,
Yes,
but not the right of the executor
correct.
or even the legal representative, the daughter.
My lord,
But the daughter does not come into the picture, taking into account that it also mentions a leader who intermingles with the estate of the deceased.
but the right to the property, perhaps that may be the logic of 2014, and my lord, perhaps that's the logic, my lord, of my lord, the other judgment, my lord, of my lord, Justice Wanchu. Saying that if the right to the property is dependent on the will, my lord, I'm only again, my lord, just looking at it because I don't think, my lord, that is, my lord, really coming out, my lord, in that sense, my lord, only my submission, if my lord wants to, my lord, accept it. Perhaps, my lord, the distinction, and I found some lines there, my lord, in paragraph 7. If the right is dependent on the will itself, perhaps then they're saying that 213 just hold on. Because here, my lord, by reason of abeyance in the suit, it is not really, my lord, affected in that sense anymore.
Here the trust cannot be. In terms of the Justice Wangsu's judgment,
Hello.
the trust cannot be made the plaintiff.
No. The executor has to be made the plaintiff, correct?
Executor has to be made the plaintiff
He has to
because
substitute himself in. My lord, I see what, my lord,
he intermingles with
Well,
the estate of the
what has
deceased.
come from, my lord, my lord, I see it. But the problem, my lord, is with regard to, my lord, whether today, my lord, in 2014, when this position has been accepted, and I'll show, my lord, the subsequent civil division judgment, which was also, my lord, the specially petition, my lord, was dismissed, my lord, by the Honorable Supreme Court. Because we might have some, my lord, difficulty there.
Where is that?
My lord, kindly, my lord, look at, my lord, in my reply affidavit, page 218. Because they, my lord, sometimes, my lord, they try again, my lord, to come up instead of, my lord, finishing of the probate there. They try and, my lord, see, my lord, whether they can get an order, my lord, according to us, my lord, in the suit itself. At page 218, my lord, in the reply affidavit, my lord, in IA. 255, my lord, has that, my lord? It should be, my lord, a judgment dated 26 July 2021. Two 220, my lord, at the top, my lord, you'll find. Then paragraph 10 onwards, my lord, at 221. Paragraph 13, 14. Thirteen, 14, 15, 16. My lord, I'm not reading because I think my lord reads faster than my lord I do. So, my lord, I'm not. Especially petition, my lord, is at page 2 to 6, my lord, which will be.
Indian succession accommodation.
Indian succession.
But section 211
Yes.
recognizes the executor to be a
Correct,
legal
correct.
Indian succession.
Correct. My lord, the will is also annexed, my lord. We have annexed that, my lord wants to have a look at it, my lord. We have also annexed that. Okay, do you have it? Do you have it? Well, we have a copy, my lord, if it helps.
This, against this matter went to Supreme Court.
Yes, my lord. That is, my lord, at page 2 to 6. The special petition is also next, my lord, but it's 2 to 6.
But in effect,
Yes,
what was challenged in this matter before this court
yes.
was that issuance of notice upon the respondents upon an application being filed by them for abatement of the year. So that is why on the ground of natural justice, the court did not.
No, my lord, paragraph 15, my lord, will find at page 2 to 4. My lord, they went on harping, my lord, even in the other appeal, my lord, that's the case, that the suit has now abated because there is no substitution. Paragraph 15 at page 2 to 4, my lord, will find. And it says, my lord, the paragraph 15, my lord, will find. Therefore, this court, first, my lord says, court has already agreed that till the probate is granted to such and such, TS 41 should be kept in abeyance. Therefore, this court is of the opinion act of filing the petition before the learned court below, seeking an order that the TS 41 of 2012 should abated, is contrary to the spirit of the order passed by this court in CRP 47 2014 and CRP 97. I'm constrained to hold that the petition miscellaneous 22 filed by the petitioner is a misleading one.
And who are you actually?
I'm the executor.
No, who are you? You are merely an executor.
I'm an executive, my lord. I'm also, my lord, the companies, my lord, which are there. I'm not a beneficiary, my lord, under the estate. I'm the executor, but I'm also, my lord, really, my lord, the company's, my lord, main person. And my lord, he had, my lord, the will is there. My lord, can have a,
Where's the will?
my lord, will is at page 323. 23. And all the other family heirs, my lord, have given consent. The daughter-in-law of a predeceased son, the other daughter. In fact, 324, my lord, will find, my lord, she was disinherited because there was a lot of, my lord, acrimonial, my lord, between, my lord, the father and daughter.
See, the judgments, subsequent to judges' bench judgments are directly to that point. Whereas the three judges' points, judgments, and that these are not points in issue.
My lord, I don't know if my learned friend, my lord, wants to rely, I don't know, my lord, how much 20, because, my lord, we are really, my lord, stuck with the situation, my lord, where, my lord, the 2014 order looks at us. And, my lord, no one having, my lord, really taken any steps from there. We've accepted the position and, my lord, gone on. In fact, my lord, I've got orders, my lord, to show, my lord, in probate, they're taking time.
No, that is a different thing. But
That's a
what-
different
wha-
issue.
What do you say about Order 22 Rule 5?
Order 22, Rule 3 and Order 20, Rule 5.
Five.
Rule 3 is the substitution. Just- Determination of question as to legal representative. But unless, my lord, again, it's dependent on the question of, my lord, the probate. Probate, my lord, can't be
Why is
granted,
the
my lord, by this
probate
court.
required? Once you have the probate,
That's
you get your, but by operation of 211, you are already a legal representative.
I should be. But 213 comes in and says
213
no right can be established.
213 is that you can exercise your powers. You can exercise your powers for the purpose of giving the effect to the probate. Once a probate is being given, this is 213. But it cannot be because by operation, therefore 211 makes you a legal representative by
Correct.
operation of
I'm
law.
not- my lord,
And
it's been a vexed question, my lord, from what I could, my lord, my lord, understand, my lord, from all these judgments. But, my lord, then, my lord, we were faced with 2014, that's the situation. Now, my lord, whether, my lord, we can unscramble it or not, my lord, that is, my lord, an issue, my lord, which, in my most humble submission, my lord, to perhaps, my lord, that will be difficult. Because how, my lord, the court has proceeded, how the parties have proceeded. He might think he's agreed because, my lord, the status quo order is there with the shares. But I am also agreed because I can't exercise my right. If probate was granted or, my lord, whatever it is, shares were in my name, my lord, I would have exercised rights in respect of the shares.
Mr. Banerjee, this court is concerned out here. You see, if you see the CPC,
Yes,
one thing very good about the particular document, the act, is that everything is simple. And you can very well apply everything has been duly taken note of. Except the subsequent amendments which have happened has made it more bad. But earlier, the CPC it includes everything.
the principles are there.
Every possible scenario
Absolutely.
is being taken care of.
Absolutely.
So therefore, while defining the term legal representatives in 211, the court categorically mentions that anyone who intermingles. This is being done taking into account that and subsequently 211, they make them a legal representative so that it can gel with 211 and then you can go ahead under 22.3 or 22.4
22.
or
Three,
the court
yes, yes.
and the court can very well adjudicate under 22.5.
22, my lord, perhaps question of probate, because that, my lord, I
No.
have my lord,
What is the decision the court is required to take?
whether your
court-
determination of question, whether you're legal representative or not.
Absolutely. Now, by operation of law under 211, you become the legal representative. This is a very fundamental aspect which has not been taken into consideration, but although the subsequent Supreme Court judgments take. Now, the three judges bench, with due respect, do not take note of. Once your judgment is on the point that that particular lady who had bequeathed the property in favor of the daughter did not probate the will made by the mother. That was the issue. So therefore, it was said that without the probate being done in respect to the earlier will, Mrs. Mitter could not have bequeathed the property.
My lord, I'm not, my lord, joining issue, my lord, what has fallen from my lord, I'm not, my lord, at all saying, my lord,
So
anything.
therefore, that is the
That-
you
but my
have
lord,
to
we are-
see the judgment in that
But
context.
we are, my lord, faced with, my lord, in this matter, my lord, the 2014.
The 2014
That's
judgment.
what, my lord, we have accepted.
No, it is okay, you have accepted it, but the question is 2014, you see the suit has to proceed. I'm not concerned with who gets an injunction, whether the injunction is required to be kept out there, let it be restored. But you cannot keep the suit pending like this, nothing happens.
Not unless, that's how, even the Honorable Supreme Court in 2021, did not interfere with that.
You see, the question is different.
Because may I just show some one
See,
thing,
you see, if you see the 2021 judgment of this court is on the question is they filed an application seeking that it should be abated. The court wanted to issue notice and against that they have come. And therefore, in the penultimate paragraph of the judgment, this court holds that it is not.
That's an additional
without-
ground, because just before that
No,
paragraph
that is the
15,
main ground.
just paragraph 15, it says something else. And in the special petition, all these grounds were taken. I also annexed the special petition, which is at 273 onwards, 272 onwards, really.
Mr. Banerjee, the special petition has been dismissed, merely dismissed without
Correct,
granting a
we
leave, so it
can't,
has
We can only say, the fact, from the special
so-
petition
so
itself.
The order passed by this court. Now, the question is whether the order by which stops this court or prevents this court from passing an order in a 151 application. 151 is again 3 years, another problem.
There are some, I think, issues, which,
Well, so far as my learned friend is concerned, before the trial court, they plead for substitution. Today, they cannot argue that no substitution cannot be granted on this ground of death. That is my first objection, man. My learned friend's client wanted to be substituted. Today, how they can argue that no, I cannot be substituted because of the 3 judges bench. And as your lord.
No, those 3 judges bench have
I
no
don't
value.
think so.
But how do I take care of the 2014 judgment? Tell me that.
My lord, I am on that. So, my lord, before that, my lord, let me, my lord, just submit what has come from your lordship also. In the judgment of my lord, Hemnalini, I'm sorry, Naranda, 3 judges bench on which the learned trial court said that the judgment was not seen, etc. And there it was never an issue as to who should be substituted, what is the
That
law.
was never the issue.
No.
That was never the
In
issue.
one
In fact, the court had observed, it is something like recently a judgment has come. So for now, you find many judgments also being delivered.
My lord.
There was a judgment in Bombay High Court wherein what had happened, the judgment was reserved. And after a few days, when the court was not holding that roster, the court again heard the matter and passed an order. In that context, the division bench, the Supreme Court said that if that was so, they should have taken the permission of the Chief Justice or whatever may be.
To take care of the matter.
Now, this has now gone beyond the proportions, wherein many courts, many administrative orders are being passed.
Right.
But it was in that context which was. Now, here also, it was never an issue in both the cases.
Absolutely, my lord. If your lordship, I'm just reading one part here.
No, it's okay.
My lord.
I am satisfied with that. But
My
how
lord.
do you take care of the 2014 fiasco, which you have not you have challenged?
My lord, for that, my lord, I have filed an IA under 151. And for that, I'm relying on one judgment of the Supreme Court, my lord, to submit that 151 your lordship can invoke even today.
Which you are referring to 98.
What was that? 2011, my lord. KK Velusam.
What does it say? Indian hotels.
No, well, this one is KK Velusam. It was a case where, my lord, after the amendment of CPC in 2022. Yes. 2011, 11 SCC 275.
275.
275. KK Velusam versus N. Palaniswamy. That was a case, my lord, where the prayer was for recalling a witness who was already examined and at the argument stage. Well, para 12, by referring to various judgments of the Honorable Supreme Court on section 151 CPC, the Honorable Court says, Supreme Court says, well, we may summarize them as follows. A, section 151 is not a substantive provision which creates or confers any power or jurisdiction of courts. It merely recognizes the discretionary power inherent in every court as a necessary corollary for rendering justice in accordance with law, to do what is right and undo what is wrong. This is very important, my lord. That is, to do all things necessary to secure the ends of justice and prevent abuse of its process. B, as the provisions of the code are not exhaustive, section 151 recognizes and confirms that if the code does not expressly or impliedly cover any particular procedural aspect, the inherent power can be used to deal with the such situation or aspect, if the ends of justice warrant it. The breadth of such power is coextensive with the need to exercise such power on the facts and circumstances. C, a court has no power to do that which is prohibited by law or the code by purported exercise of its inherent powers. If the code contains provisions dealing with a particular topic or aspect, and such provisions either expressly,
Mr. Mazumdar, this law is there.
my lord,
No quarrel with that
My lord.
proposition. But how do I exercise that law
my lord, I'm
as of now?
My lord.
After
limitation will not possibly come in the way, because my lord, this is a case where your lordship is seen in view of Binapani's judgment. Binapani, may your lordship will just permit me two paragraphs from Binapani, my lord. Here directly the question was, what will be the law with regard to impediment sought by a person as a executor, as a plaintiff originally, and a person coming as an executor of a will subsequently. And in the context
where is
of
the
section,
judgment of Binapani?
my lord.
And Hemnalini was duly taken note of.
Yes.
And if Hemnalini was taken up by the division, by the court and then decided,
Yes.
it cannot be said that it is per incurium.
Yes.
This court is absolutely wrong on this aspect.
Well, I'm
Where the right of either of an executor or legatee under the will is in issue, such right can be established only when the probate is there.
where
Does
executor
not
was
come in the way of a suit of a man.
Section 213 does not come in the way of a suit or action being instituted or presented by the executor or the legatee
This is the
claiming.
law.
My lord,
As I told you, this is the
My-
law
my-
from the beginning.
my lord.
You don't invent the requirements. You see, I'm reading of 211 and two, both 211. One is 2 bracket 11 and the other is 211.
My lord. Yes.
Makes it absolutely
Incidentally.
clear.
Yes.
By operation of law, he is being made a legal representative.
Yes.
Done.
And he is only representing, my lord. This judgment Binapani says,
And further, it says that tomorrow, if he wins the case,
yes, this judgment will be effective.
then that judgment would be effective.
And before that,
And
it
this
will
very
not be
judgment
enforceable.
was not taken into consideration,
Yes.
taken and not looked into, where it categorically says that this is it and have been made per incurium.
My lord, if your lordship kindly takes up the
That
judgment-
everything said and done is okay, but how do I undone a thing which is done? And Mr. Banerjee, I also ask you to help this court As to how do I undo the thing which are wrong, which has been committed?
But,
My lord, in my humble
little,
service,
my lord, because of the time and my lord, I think, my lord, it's difficult. But my lord, even in Binapani, my lord, that's what I said, my lord, Binapani. In fact, my lord, see how, my lord, the Honorable Supreme Court also, my lord, goes away from that question. I wish, my lord, they had really helped and said, this is what it is.
Where?
My lord, kindly see, my lord, those judgments are noticed. Here, my lord, the respondent was not appearing. Then, my lord, kindly see paragraph 8. Which, my lord, I always think, my lord, the courts 142 my lord, power being used. And paragraph 5 also, I wish, my lord, they had actually, my lord, discussed it and made the law straight, because there's one line, my lord, saying that it can be substituted, and my lord again says, my lord, not.
Where?
My lord, paragraph 5, if my lord looks at it, first, my lord, hem nolini is, my lord, noticed. Then, my lord, no reasoning. Therefore, when the right of an when the,
Helen does not in any manner have any impact. I've looked in the Hemlan news. Show me which line out here. Which
I
takes
have
that
seen
into account.
paragraph 7, but there are, my lord,
No, you are, paragraph number 7 is,
my lord,
it contains
fact,
the huge paragraph.
my lord,
where
paragraph,
it-
my lord, paragraph 7, one line, if your lordship permits me to submit.
Paragraph 7, it
No,
starts, it
there-
is a
there is-
3-page paragraph
but there
7,
is-
where you
there-
were mentioning.
But there is a
Hey,
basic
Malad-
difference. In that case, my lord, there was a question of establishment of right.
Yes.
We are here concerned with the
No,
proceeding.
kindly see this paragraph out here,
fine.
where is
Yes.
paragraph 7, the beginning
lord.
of paragraph 7.
Yes.
Had executed a will in favor of her mother, Mrs. Mittal, in June to 1925, bequeathing the house in dispute to her. No probate or letter of administration was ever obtained by Mrs. Mittal. It is true that Mrs. Mittal in her turn made a will in favor of the appellant, and she obtained a letter of administration to that will. In that will, the house in dispute was mentioned as the property of Mrs. Mittal and was bequeathed to the appellant, and in the letter of administration granted to her, this property was mentioned as one of the properties coming to her by the will of her mother. The question, therefore, that arises is whether it is necessary before the court appellant could take advantage of the bequest in favor of so and so. Now, therefore, the court has observed in that regard.
Yes.
Where is that line by which the person cannot be substituted?
next, this
It
section
does not say.
clearly creates a correct. Well, I'm not again.
So
Well, this is
therefore-
what it
therefore-
says.
Therefore,
But
relying on the judgment
I
is wrong.
Lord, I can't, my lord, go beyond, my lord, what, my lord, we are with.
So, Mr. Banerjee, your thing is that you don't want to proceed with the suit.
My lord, I want, my lord, my probate to be done.
No, you don't want to
Because
proceed
I know,
with
my
the
lord,
suit.
no, I want to, of course, that was my application originally.
No. Kindly tell me now whether you want to proceed with the suit.
So of course, I want to proceed with my suit.
So then we take it, file an affidavit to that effect. That
No,
you
but
want
I
to
cannot proceed
the
with my suit in view of 2014.
That is
My
okay.
lord, let me then put this affidavit. I want to proceed with the probate as well. Because I am pursuing him in the
I'm not
probate.
concerned with the
My lord,
probate.
my lord,
No,
can you
I'm not,
see?
Mr. Banerjee, I'm not concerned with the probate. I am concerned with the suit.
My lord, I cannot, my
Now,
lord,
whether you want to proceed
my
with
lord,
the
I
suit
cannot
or
do
not.
that. I can't proceed, my lord, in view of 2014 judgment. I can't, my lord, proceed in view of 2014 judgment. That's one of the issue. I cannot proceed in view of the 2014 judgment. It's binding on us.
No. If this court on the
My lord, if
takes-
I want, my lord,
if
my
the
probate
court-
to be done.
If this court takes care of the 2014 judgment, are you willing to proceed with the
My
suit?
lord, I want my probate to be done. My lord, can you
I'm-
take care of
I'm
that?
asking you this specific question, Mr. Banerjee.
My lord, I cannot, my lord, without, my lord, the
So
probate.
therefore, the question is you want to delay the suit.
No, why should I want to delay the suit?
That is it.
My lord,
So
I
we'll
want
take
my
care.
probate to be done.
No, it's okay. We'll take care. I'm not concerned with the probate.
just-
I'm here.
just
My
one
lord,
more-
I'm not concerned with the probate.
My lord,
It's the
My
Calcutta High
learned
Court.
friend's client, my lord, is concerned with the probate.
I'm not concerned with the probate.
My lord, that's my lord,
Mr. Banerjee,
Look,
whether he is concerned with the probate, you are concerned with the probate, is nothing to do with this court concerned with the probate. This court is only concerned with the suit under whose jurisdiction, and it is under this jurisdiction that the suit is pending. I'm not concerned with what happens in Calcutta High Court. I'm not bothered to that effect. This is a fundamental mistake which has happened in this court. So we need to correct it.
My lord, one more aspect relevant. There is another suit in respect to the mother's share.
Correct.
And they are relying on Binapani. They have prayed for substitution, it was granted. Suit is proceeding. Same plaintiff filed a suit challenging sale, plaintiff was different. Same. Mother's share was gifted to daughter. That was challenged. Suit was pending. After his death, my lord, an application was filed for substitution. Relying on Binapani, substitution has taken place.
No, no, no.
There is proceeding.
I'm sorry, my learned friend is not aware that actually it's not correct.
He has been substituted based on that.
Now, I'm not going to go into.
My lord,
Here, the judgment is wrong,
my lord, judgment.
but how do I take care of it? Come up with that solution.
My lord, Lordship, may I kindly have a look at paragraph 135, page 135, paragraph 14 and 15. This is the apparent error, my lord.
No, there is an error.
My lord.
Everything is wrong.
My lord.
Let us assume that absolutely this judgment is wrong. Then how do I take care of it?
My submission is I can only rely on section 151, even order to invoke. the power.
151 you can, but
My-
the fact is, how do you take care of it, that it has not been done? You filed an SLP against that, the SLP was dismissed. Against this?
SLP, not against this, my lord. Against the order passed by Honorable Justice Indra Shah, there was no SLP.
There's no SLP.
No, SLP was only against the order passed in the pre-application for abatement.
Oh, that has nothing to
There is
do.
no bar.
So SLP was not filed. So
No,
this has remained as.
yes.
Now the question is, how do you take care of this? How do I exercise my power under 120, 150?
In order to set things right, we on Supreme Court has said that if something has gone wrong and it is it is prejudicing us, they have obtained an order. And how it is causing prejudice, manner, they have obtained an ex parte injunction order, ad interim, of course. And when we file an application for hearing our application under Order 13 and Rule 4, now they take a plea that it is stayed. It is causing serious prejudice to us. We are joint holder, they say second, we say joint holder of those equity shares. We are unable to utilize the benefit of those shares as a shareholder in the absence of the other share person, father. And they are enjoying.
But why didn't you open your eyes within 3 years?
She
Give me an answer to that.
doesn't reside in India, man.
Huh?
And she
No, I'm not on the explanation of delay, but how do I take care of it? Because there are lots and lots of litigations which have been filed in the meantime.
Right.
So why haven't you moved this court for this order? Because you could have very well sought for a review, you have not.
manner. I'm not for review. In fact, my lord, today by filing this application, we are conceding. We earlier raised objection. Today we are conceding. Your lordship only has to accept our concession. We are conceding that we are not objecting to their submission, and they paid for submission.
Who has filed this 47/2017? You have filed.
Was there? Yes, sir.
You wanted to substitute yourself.
Yes.
So
they
that was
wanted to
rejected.
They wanted to substitute.
Now, did you want to substitute? No.
No, they. I'm a dependent there. Ma'am.
So they wanted to substitute themselves
Yes,
and that was rejected
rejected on our objection.
on your objection. So they came before this court.
They also came.
And why there are two petitions? No, there is only one order.
One order,
47.
common order.
They also preferred a revision.
Common order.
Common order.
They wanted the suit to be rejected. I think that was the
In the common order.
prayer. So they also filed a civil revision. We also filed a civil revision.
No, their case was different. Their case was for what?
Dismissal of the, I'll just want to check before I make it.
Where is the actual judgment? No getting it. Your case is 47
Mine is 47.
and where, and
Theirs
97.
is 97.
Okay, they wanted actually for rejection of the claim
Yes.
on the ground that the plaintiff did not have the locus standi. So that has nothing to do. We are only concerned with your petition,
Yes.
where you were aggrieved by the
Yes, yes.
non-substitution. Now we get the point.
But the application is not in my civil, that also will kindly make a, the application which they have filed is in their petition, civil revision. 97.
So Mazumdar, why haven't you filed it in 47?
I think it's a common order.
So Mazumdar, you know, only don't show your this thing.
But
This is
yes, it is-
absolutely laughable.
It is in 90.
Huh? Why didn't you?
It is 90.
Why is your assisting counsel and making a joke of himself by filing this type of applications?
It is only-
Why?
The 97.
97 is your application by which you are aggrieved by non-rejection of the plaint on the ground. Yes, this is what has been mentioned in the order. Kindly see the impugn order, the order judgment, paragraph number 3. The respondent number 1 in this case, that is CRP 47 of the UN, has filed a civil revision petition in CRP number so and so, challenging the order dated 23/12/2023 13, passed by the learned civil judge on the ground that the plaint filed by the original plaintiff does not reveal that the plaintiff has any locus standi to file. The trial court ought to have rejected this substitution application and disposed of this injunction petition by vacating the ex parte and interim injunction order. So this is your application.
The order that was put to challenge in both 47 and 97 is an order passed by the trial court, keeping the substitution application in abeyance, and therefore the challenge in our revision was to dismiss the substitution application, not to keep in abeyance. Their challenge in the revision petition was to allow the substitution.
So your petition was for what?
The revision petition. The order challenge, this is the same order which was challenged.
Show me that.
Lordship will kindly see the order. The order that was passed by the trial court, that your Lordship will find page 111.
Page 62 of this. Is registered as so and so in 47 filed by so and so, restraining was passed by the court of so and so in respect of so and so, and further restrain the opinion from using the delivery slip of so and so. In the petition, learned counsel in some claim.
Page 111, your Lordship will find. In the IA.
This is the order.
This is the order. Here the
This suit is fixed for orders in petition number Iman filed by Somnath Chatterjee and objection filed by the defendant number 2.
I am the defendant number 2. So here, my lord, the lordship will find page 118 is the operative portion of the order.
Why on earth the learned court has come to was distinguishing these two judgments?
Hello?
We don't find these type of orders by the learned courts to say the learned trial court saying Supreme Court judgment to be pari incuriam. What is wrong with these judgments? Never heard this. Never they who may not refer. Huh?
I don't
How is it possible
all got
to say it to be per inquiry? A Supreme Court judge of a subsequently given two, not one, two judgments, not a matter of joke. The trial court says this. I've gone through the decision relied upon by the learned counsel in so and so, which is a decision of the division bench of the apex court, holds that AI is not a condition precedent for filing of a suit on human. This vesting in Binapani in so and so. In Narayan Das, accordingly, a decision relied upon by the learned, which is delivered by 3 judges, is binding. In view of the above decision, the AI cannot be impleaded and so and so. Never heard of in my entire career trial court judge writing this.
my lord, may
And
kind
there are Supreme Court judgment also to say that you can't mention a Supreme Court judgment to be per incuriam.
my lord may kindly see page 118, last 2 paragraphs, my lord. Page 118. In view of the above discussion and decision as discussed above, at this stage, petitioner Somnath Chatterjee cannot be implicated as plaintiff in place of deceased plaintiff. Hemendra Prasad Barua, in his capacity as the executor of the will of the deceased plaintiff, as the will has not been probated so far. However, instead of dismissing the petition filed by Somnath Chatterjee, executor of the will of the sole deceased plaintiff Hemendra Prasad Barua, following the spirit of the judgment in Binapani court, Lordship will kindly see, and another, and with a view to do complete justice between the parties, the petition filed by Somnath Chatterjee is kept in abeyance. Accordingly, this suit is kept in abeyance. So his substitution petition is also kept in abeyance. And suit is also kept in abeyance. This is the order we have put to challenge in the revision. By this order, both of us were aggrieved. We were agreed by not rejecting their application because this was not rejected. And they were aggrieved because their petition was kept in abeyance.
FAO will deal it later on.
My-
Let me first dispose of this matter.
In fact, madam, I do not know which way it will go. If it goes in our favor, then appeal will go back to the trial court because they have not taken a decision on merit.
We'll pass the letter.
My lord.
Will the hearing complete.
But only
Judgment.
one, my lord, on that issue, 151 also, but what has fallen from, my lord, one judgment, my lord, may I just give the
For what?
reference? My lord, on 151, perhaps 151 par, my lord, as it may not be available, my lord, just, my lord, the judgment, my lord, may I just give that reference to my learned friend and my lord, to the court?
What judgment?
My lord, saying, my lord, that 151 cannot be used really to recall an order.
There are many judgments of the Supreme Court which allows that 1993 SCC which says. You want that?
This is, my lord, 2022, 19 SCC
What does it say?
806.
Show me.
Just kindly, my lord, have a look, my lord. I am again, my lord, not, my lord, kindly do not. 2022, 19 Supreme Court cases, 806, my lord, just consider that, my lord, when, my lord, is.
Page?
My lord, page 806.
What does it say, actually?
Not,
You read the judgment, or
I
you
will not-
just
will not
taken out?
just now, my lord, on the, though, my lord, it's a third party on the question.
Says
of
that
third
150,
party.
this is from Manohar Seth, the judgment of what is it, 62 Supreme Court.
Where, my lord,
When he says that when there is an alternative remedy, you cannot
Specific
invoke
provision.
151. But the power to recall is given out there in the judgment of 1999. Indian Bank, 96. Is being referred to. Inherent power of the court, nature, fraud committed before amounts to abuse and all, whatever may be. There are 4 grounds which have been given.
yes,
This is the judgment. Wherein it says which are the grounds on which can be done. Paragraph 22, the judiciary in India also possesses inherent power specifically under section 151 to recall its judgment or order if it is obtained by fraud on court.
correct.
In the case of fraud on court to the suit or proceeding, the court may direct the affected party to file a separate suit for setting aside the decree obtained by the inherent power here which are resident in the court, especially of superior jurisdiction. These courts powers spring not from the legislature but from the nature and constitution of the tribunals or court themselves, so as to enable them to maintain the dignity of the and to the process. So this is it. Then in this judgment, we will charges on this is on the 1999. Where is the judgment? Well, here there is no other relief. There's no other remedies available to either of the parties. So how, what to do?
I think, my lord, I made my submission, my lord, I leave it, my lord, entirely. Up to my lord.
Nine 4 SCC 396. I was right. Swain versus Gopinath Dev. And this judgment is being followed in many other judgments also. Right to invoke inherent powers of the court to recall, right to seek vacation of a judgment may be lost by waiver, estoppel or acquiescence when the ground for reopening of a proceeding or vacating other was available to be pleaded in the original action or a not properly pleaded. Vacation order of judgment and made on an exception filed beyond the prescribed for pleading the vacation of the proceeding of the Yes, referring to Antule, it is in Antule, this court had noticed motions to set aside a judgment being permitted where a judgment was rendered in ignorance of the fact that a necessary party, a judgment was obtained, a party had no notice and no decree was passed. Then further it said, there has been a mistake of the court prejudicing a party. '99 for SSU, but
Sorry, my lord,
judgment reserved.
About my hardship and the fact that I am not objecting now to their substitution, I have mentioned para 28 that may kindly. All right.
That FAO will be listed separately. First of all,
No,
I'll
whatever
deal
the-
with this. Any urgency?
They have find that Sonapur matter, my lord. They have find that, my lord, Sonapur matter, my lord.
What has happened?
Affidavit they have filed, my lord. So, my lord, it was listed on last occasion also, it did not fix. So can it be fixed on top of the list?
Well, madam,
Circle officer has.
They have filed an affidavit, madam.
State government has filed it affidavit.
who is in possession?
Hello?
Who is in the possession? They.
Yes, CRPF.
Now have in the affidavit, does it clarify your your land?
Whatever they have, they have stated, it supports my case, madam.
In the affidavit,
Yes, in the affidavit. But
by
it
the
was-
circle officer.
By the circular.
They
That-
have tag number 5, but 5 is a road, my lord, as per the,
That has been made wrongly. Yes, Mr. Henry. That is wrong, na?
So they are searching still, my lord, are busy in the election, they could not be, my lord. Father, my lord, that. I think the affidavit which has been filed at page 84, my lord. They, what is the stand of the petitioner? They are saying that tag number 49 and 5, that patta numbers, from patta number 6, tag number 5 in the.
We have it on another date on which date we'll ask them to demarcate it. Once it is being demarcated and say as to in whose possession it is, that area, then we pass an order. If they are in occupation of that, either we give them an option either to acquire the land or give it back to them. That is the only way out. Chalo. Mr. J. Hendrick, the learned counsel appearing on behalf of the respondent state submits that taking into account the ongoing panchayat elections, some time may be granted. Some time may be granted for in the matter. It is, however, however submitted that the affidavit has been filed by the circle officer, concerned circle officer after making certain after making due verifications. List the matter on 3rd of June 2025 at the top of the list.
Item number 10, Madam, with the MSc appeal, accident took place in the year 2004. MSc case of 2006, my lord. The insurance company has filed an appeal. Lordship may fix a date, my lord.
Item number
Item number 10, my lord.
10, huh?
If possible, at the top of the list, my lord.
Who has filed the appeal?
The insurance company.
Item number 10, let it be listed on 2019 at 2 p.m.
Lordship, deeply obliged, my lord.
Item number 13, I am for the petitioner.
Ah.
My lord, can it be date will be fixed for it?
What is the matter about?
My lord, I am the defendant in the suit. My lord, their suit was dismissed for default and my counterclaim was allowed. They filed an application under Order 9, Rule 9, then Order 9, Rule 13. Without going through the applications, the trial court disposed of the matter without condoning the delay, even with then the application due to change of jurisdiction, when it came to the Municipal Court, Junior Division, then their application was dismissed for default. But against that order, I have come before that composite order, without looking into the applications, the previous trial court has passed that order. Now, then thereafter, it went back to the Municipal Court, where the Municipal Court, their application was dismissed for default, whereas earlier it was allowed. But the application remained pending before the trial court, because
No, wait. A decree was passed in your favor
my favor, counterclaim,
and their counterclaim was dismissed.
their plaint was dismissed, suit was dismissed. Suit
The
was
suit was dismissed and counterclaim was
decreed.
decreed.
They filed two applications.
They filed two applications, one under section 5.
One that is for miscase for section 5, Order 9, Rule 9, then Order 9, Rule 13,
They filed an order 9 rule 13.
13 and Order 9, Rule 9,
Why 9?
because to restore their suit.
Okay, so suit restoration and the other one is this. So both the applications have been allowed.
While both the applications are allowed, against that allowed, there is no appeal, it should be 227, so I came before this court. Now, when it was renumbered and due to jurisdictional change, when it went to the below court, in the Municipal Court, my lord, their application was dismissed for default.
Which application?
Their application for Order 9, Rule 9, which was kept pending and it was not disposed of, but the court, while deciding their Order 9, Rule 9, also disposed of the Order 9, Rule 13 without going through the application of Order 9, Rule 13. And the miscase was not registered for delay condonation. So all this was kept pending.
These are simple matter. Item number, that is your item number?
13.
13.
13.
Okay, 13 to be listed on 21st at 2 p.m.
Well,
Item number 14, my lord. Item 14, my lord. Can a date be fixed, my lord? Matrimonial appeal, my lord. Appeal against grant of divorce.
17 June.
My lord. Highly obliged.